Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Moorian Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. Moorish Empire, traveler on the land, bitch snitch, Moorish Empire, God dang, you're right, traveler on the land, bitch snitch. The late evening U.S. people.
Into the mud, scum queen!
Hey, good morning, good afternoon, good evening, good night, everybody. Whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, however many times you plan on doing it in the future, I'm just glad you're doing it here with me, Legal Vices, on my little old channel I like to call Legal Vices. All right, first big thing, we got a chair. We got a chair. It's exactly the kind of chair I didn't want. It's a swivelly chair with wheels, but you know, sometimes you just got to give up your dreams. Just a wiggly little chair with wheels from Costco. The nice big chair is taking its place back in the whiskey room where it belongs. So it's the universe has achieved stasis once more. I am exhausted. I'm completely wiped out. I'm completely drained, but I'm here for you guys. I wouldn't miss this for the world. During the Hannah Gutierrez trial, I've been getting about 2 to 3 hours sleep a night for the past 10 days, doing 2 streams for the last 4 days, do this for a couple hours, then do that and all night long in Korea time. They had the verdict this morning, so I got to do 3 shows all night long. Then I got 2 hours sleep, woke up, did the verdict, went to work, came home, got everything ready, and I got right here. So tonight's going to be a nice night. When I wrap up here, I'm going to sleep. I'm going to sleep the sleep of the just. So we're going to have fun. We've been watching, for the last 2 days, we watched part 1 and part 2 of the first hearing. And the second hearing was scheduled for December 6th, which seems to be a sore point amongst the parties and the judge in particular. So today we're going to be watching hearing 2, the infamous, the legendary December 6th hearing. So welcome everybody. We're doing so good. We're coming up on 69,000 subscribers. The big 69. We are in fact 83 subscribers away. We're 83 subscribers away from hitting 69,000. That is awesome. And as promised, when we get to 69,000, we will do a huge 69 party. Everybody's invited to 69 party. That'll be that'll be a week from this Friday, what I call F It Friday, where once a month we just say F it. We have a big griftathon where I try to liberate as much money from you as possible in one day, so we don't have to do it the rest of the month. It's basically shots for money. Every $100 that comes in, I do a shot of strong, expensive whiskey, and it crushes my soul to disrespect such great whiskey in such a manner. But we have a great panel of guests. The initial panel is almost ready for release, but I can tell you that so far we have, who do we have confirmed so far? We have Flux, we have Waifu Kron, formerly known as Waifu Kron Jazz, but now she's Moxie Dame. That's what she goes by. Aussie Overlord Hayden will be here, and a bunch of others. We should be able to get the initial list out tomorrow. So that'll be fun. Just check, because we go all night. We go until you run out of money or my liver gives up. One of those two. One of those two things has to happen for me to tap out. And we have fun. But that'll be a combined St. Patrick's Day. So, I mean, what's this grifty booze more than St. Patrick's Day? It'll be a St. Patrick's Day super special, huge 69 party right here on Legal Vices. We can all 69 right here on my channel. Celebrate it. That'll be a week from Friday, probably about 7 to 8. Kick off about 7 or 8 p.m. Friday, Eastern U.S. time. But until then, we're going to keep doing the Preston Hales thing and anything else that's, for example, tomorrow, Friday, our Friday streams, we don't do Friday morning streams. We do Friday evening streams. Tomorrow's Friday evening stream will be a very interesting development in the Maya Kowalski case, the take care of Maya. There's been a new development, and I'm going to be covering that here Friday night. That's going to be fun. So stay tuned tomorrow, or I guess it's tomorrow, or is it? Yeah, see, this is the problem with datelines. I always forget where it is. Yes, tomorrow is Friday for just about everybody. Friday evening U.S. time. Stay tuned for some big developments in the Maya Kowalski trial. That whole big mess. It's not over yet. All right. Well, that's just about all we have here. We've done enough. We've given a lot of time for people to come in. We got 300 people here now and 153 likes. So half of you haven't done your job. Get down there, smash that like button, smash that subscribe button. And if you are subscribed already, just double check to make sure you're still subscribed, because YouTube is asshole and unsubscribes people all the time. And we want to prevent that from happening. We don't want you to miss this awesome show of mine. But some people don't think that. I got an email yesterday, and I wouldn't want to misquote it here. I don't get nasty emails. I'm pretty darn lucky in that respect. I think I've got like 2 or 3 things. Like somebody said, you talk too much. See you later, Gabber, or something like that. I had someone say something a couple of months ago. By and large, I don't get nasty mail, but I got one yesterday. Where did my nasty mail go? There it is. We'll keep his name private. It's very short though. It's from this person. You open it up. It says, to me, you have to be one of the most annoying guys on YouTube. That was the email I woke up to this morning. That was the first email in the list. You have to be one of the most annoying guys on YouTube. I said, well, lol, thanks for watching. Hope to see you again soon. Never again, was the reply. So, well, that's too bad. How did I annoy you? And no response. So if you're watching and you know who you are, I hope you're hate watching at least. Well, let me know how I annoy you. But yeah, you have to be one of the most annoying people on YouTube. And that's saying a lot, because there's some annoying mofos on YouTube here. So anyway, Patrick Imkins, it's okay to use my name. Yeah, it wasn't you. All right. Yes, somebody took the time to email that. I think it's hilarious. But anyway, oh, by the way, if you do want to send emails or anything, it's thelegalvices@gmail.com. Also, The Legal Vices on Twitter. You can hit me up wherever. All right. Let's see what we got in the chat department here before we take off with today's shenanigans. Unhung Hero with the $2. Thank you so much, Unhung Hero, for kicking us off. You are number one. And by that, I just mean the first super chatter. Thank you so much. Hey, all you cool turtles and tortoises. Oh, do I have to say that in Tug's voice? Hey, you cool turtles. Turtles. No. Why was I making him sort of sound like he's from Joe Country? Hey, all you cool turtles and tortoises. It's weird that I have to. Right, all right, I'm just gonna give up because I kind of got my Utah accent. I can do my Utah accent, but I can't do kind of like a Tug accent. But yeah, I'll let my betters do it. Jill M's, what's up, Jill M's? My liver screams at me every night. Well, you just have to feed it more, and then it'll love you forever. Stingy, sorry for the email. Meant to send it to Ozzy. That's just mean. Stop that, Stingy. But here we are. That's it. Kentucky, you need to stop, says Elizabeth Moody. All right. Take our like and subscribe poll, by the way. Once you've hit the like button and you've hit the subscribe button and made sure you're still subscribed. Our like and subscribe poll is we just take it every day to remind you to do all the YouTube stuff. What is your favorite part of Tortoise Queen Ranch? What's your favorite part of Tortoise Queen Ranch? We've all seen the video, I believe, or most of us have the Fish and Wildlife video where they came and they did the walkabout for the house, and so we saw a lot of stuff. What was your favorite part? The trail of broken glass, which I didn't know whether to call it like the trail of so it's like a trail of tears thing or like a crystal path, but I thought that would be horribly disrespectful. So we just went with the trail of broken glass, or as Megan Fox calls it. What does she call it? She calls it the toddler something. the toddler trail, the toddler gauntlet. That's what she calls it. She calls it the toddler gauntlet. So yeah, the trail of broken glass, aka the toddler gauntlet, the shit shack, the swamp of despair where the tortoises live, or the maybe bobcats or mountain lions she may or may not have on site. Just take the poll. We'll look at it. We'll look at it here in a little while to see how things go. All right, before we go, we do have a new character, because yesterday while we were watching part one, while we were watching the first hearing, I learned something that kind of disturbed me. That her former husband, current paramour, was nicknamed apparently by Jeremy Septic Boy, which I thought Septic Boy was really hilarious. So I had to add Septic Boy, at least temporarily, to the Tortoise Queen and Judge Grudge thumbnails. So let me, if you didn't see the thumbnail closely, let me show you what the thumbnail was. We're gonna stop that screen, share this screen. All right, there we are. This is our cast of characters. Jeremy Hales takes on Judge Grudge. Of course, Judge Grudge is here in the middle, wielding his enormous gavel as a symbol of his disdain and madness. We've given him a nice shiny silver codpiece today. So we've got Judge Grudge here, and of course we have the Tortoise Queen herself, dressed up in all of her Tiger King wannabe gear. And here on the right, we've just introduced temporarily the new character of Septic Boy. I just thought it'd be nice if he was just kind of a dumpy looking superhero. So yeah, we created Septic Boy over here. That's our cast of characters. That's all. Just me being childish here on the internet. And with that out of the way, take a deep breath and let's get involved. The doggo cam unlocks. That achievement gets unlocked at the $100 super chat gifted membership, purchase membership thing. But let me take a quick. What a great wine. All right. Before the December 6th trial hearing happened, there was another submission by LIEnette Preston. 2 days before, on December 4th, 2023, she submitted a supplemental affidavit in support of petition for injunction for protection against stalking. 2 days before the trial. So I want to look at this. It's handwritten, and it's damn near illegible to me. So I'll stumble through this. If you want to stumble through this with me, you're more than welcome to do it. All right, ladies and germs, I'm going to have to embiggen this as much as possible so that it's legible to some extent. This is the supplemental affidavit in support of petition for injunction for protection against, and she's checked, stalking. Full legal name, LIEnette Preston. That doesn't sound like her full legal name. When she talks, she has about 38 different names. So I don't know, but she said that apparently she says that's her full legal name on this document. Being sworn, certify that the following statements are true. Again, this is a sworn statement punishable by perjury and all sorts of icky things if it's proven to be a lie. On date, December, or on the 3rd or 4th December. She doesn't remember? On 3rd or 4th of December at Otter Creek, PO number 1, Wednesday morning before court. Jeremy drove. Okay, respondent said or did the following things that hurt me or a member of my immediate family and made me afraid for my or my family member's safety. So before court, Jeremy drove past us while we were parked in front of courthouse. He went, and again, even when she's printing, she can't use capital letters, punctuation, or paragraph breaks. He went and made U-turn and came back by us and had camera out, had camera out window yelling, 10 feet, 10 feet, you're breaking the order. I actually kind of find that funny. Fans, look, they are oh, god dang, punctuation, bitch. 10 feet, you're breaking the order. Fans, look, they're breaking order. He did that 2 weeks prior at our home while we measured fence. Thursday or Friday, I went to past office. What is this? In Otter Creek and didn't notice any of their vehicles. I thought they were both in, as they said. To judge, they weigh so be, but I guess M Risk was, I don't even know what that says. M Risk was in there. They made a video, which I can't play. Which I can play or can't play? Which I can play. All right. Please indicate here if you are attaching additional pages to continue these facts. 10-foot center. Oh, God. They claim we're posting online lots of things. I've showed my P to law enforcement. Okay, I've showed my phone to law enforcement. Not posted at all. God dang, woman. For the love of God. Learn to spell, learn grammar, learn punctuation, just a little bit. So, all right, we continue here. On date 3rd or 4th December at, she didn't put in the address, but it's already on the front page. So they made a video of me walking into first lobby. I got my mail and left. I left with my back towards main lobby / clerk. I never saw her. Hales' attorney called me on phone. Hales' attorney called me on phone while I was shopping. He made multiple offers to me of cash. He made multiple. What? Hales' attorney called me on phone while I was shopping. He made multiple offers to me of cash or proceeds from Mr. Hales' video or foretelling his fans to leave me alone. He said, "What can we do to end this? What would it take?" I said, "Nothing but an order to leave me and my family alone." Okay. So here she is accusing Mr. Feathers of it doesn't sound like she's saying it's a settlement offer where the parties get together and go, all right, we'll compensate you for something. We'll give you something on a nuisance basis. What would it take to get everybody to leave each other alone? She's basically accusing him of bribery here. which now I understand why he's not why he's not the lead attorney for the Hales right now, because he's just become a witness. Yeah, so that effectively takes him out of out of the running as a lawyer now that he's basically become a material witness in this case. Yeah. Oh, yeah. Oh, that's right. The judge said to try and work it out. You are absolutely correct. Where did that go? I forgot about that. Who said that? Who said that? Where'd it go? There's so many of you, and it just scrolled past. But yes, someone mentioned that here in chat, and that's right. Right at the end of the previous hearing, they said, work it out. Try to work it out before December 6th. So okay, yeah, he was. It seems like the lawyer was, because there was some question about whether the wording of the Ohio injunction order would prevent not only Jeremy from contacting the tortoise queen, but also his lawyer from talking to her. There was some discussion about that, so I guess they resolved it. And this seems like the lawyer was reaching out, but she's couching this thing in terms of bribery. He's offering cash or proceeds from videos, or I guess oh, this is so weird. So, all right, that explains why Feather is no longer involved, because now he's a witness in her accusations of bribery. Ugh, how distasteful. Please indicate here if you're attaching additional pages to continue these facts. Well, that is certainly checked. Leave my family alone. On date, the following incidents of stalking occurred at the following locations. The locations may include, but need not be limited to, a home, school, or place of employment. The video said they're getting paperwork to get us in jail in Ott. I guess that's Otter Creek. They say we're putting things online, and we are not. For cyberstalking, the following is a description of all evidence of contacts and or threats made by respondent in voice messages, text mails, and other electronic communication. I'm following the order to a T, or is that a T minus? They want us in jail and are frauding and using the legal system to do it. Well, hello, kettle. You're black, says the pot. Jeez. Please indicate here if you're attaching additional pages to continue these facts. Oh, of course it's checked. Please indicate here if you're attaching copies of medical records or treatment you may have received or injuries referred to in your petition or in a supplemental affidavit. Copies of any police or sheriff's reports concerning incidents of violence involving you and respondent, or any of the inmate or any notice of inmate release. I'm afraid he's making up lies. I've done here to get me arrested. He's making up lies I've done here to get me arrested. What in the hell, woman? Okay, god damn. Punctuation, biatch. I'm afraid he's making up lies I've done here to get me arrested in Ohio. To stop this action since I didn't take his attorney's deal. Oh, now it is a deal, not a bribery. What a weirdo. All right. Well, there it is. Sworn 2 days before the hearing. Right. Well, that was incomprehensible. Was that as bad for you as it was for me? That was unpleasant. It's going to take me a while. Sorry if I'm shifting around. My chair hasn't been swiveling for quite some time, and I got to get used to this chair here. Wow. All right. I want to know if Feather recorded this said bribery. If he wasn't recording everything before, he will now. I would tend to agree with you, Satori Hikes. Yeah, are you afraid Attorney Silverman is stalking LawTube? LIEnette's Attorney Silverman slipped into TugStream yesterday and tipped $2. What? No, it can't really be. It can't really be him. It can't really be him. What's he doing? Looking to return to Judge DeThomasis? No, it can't possibly have been the real him. It had to be someone just changed their name to that. I hope that would be too weird. All right. Well, Well, I mean, see, it depends how it was. If he's like, look, the judge told us we got to try to work this out. We're willing to, to do something just to get you to leave us alone. We'll give you, if you feel you've been damaged, we'll pay you a little bit of money. And then everybody withdraws everything and we just forget each other exists. We'd never talk to each other ever again. Just some sort of deal like that. That's negotiations there. That's negotiating a settlement, a resolution, an amicable resolution to the problem. When it's bribery, is like, here's some money, if you just drop everything and go away. You don't have the framework for a settlement agreement. Or, it's like, we'll drop, well, I guess it's not bribery if you say, like, we'll drop this if you drop this. She's making it sound nefarious. I mean, have these people, her and Septic Boy, have they nothing better to do with their time? This is just astounding. This is, okay, that would be too bizarre. It wasn't the real Silverman and Tugs chat. Y'all stop perpetuating a lie. You could tell by the last 4 words in parentheses, not the real Silver Scam. Well, that's a good indicator. I would guess that would be a good indicator that it wasn't the real Silverman, but why it would be the real Silverman in the first place would just be that would make less than 0 sense. All right, we've got through the first part. There's 3 parts of today. Now we move into the second part. This is the main course. We had the aperitif. We had the appetizer. Now we're going to get to the main course, which is hearing number 2. Hopefully we'll get through all of this today. Looks like we got about an hour and 16 minutes. And again, I don't have a trial to do after this, so I can stay a little bit longer if necessary. I'll just have to try not to be as chatty as I normally am. So, all right, we'll just pause this and talk as any of the super chats come in. Just make sure you hit the like and subscribe while we continue. 575 people here, 284 likes. Keep it coming. And again, we're just kind of grifting for oh, hey, we are 74 subscribers. 74 subscribers away from the big 69,000. Let's keep those subscriptions coming. Oh, there's so many innuendos I could make, but I won't. Even the word innuendo is an innuendo, isn't it? That's why I like the word innuendo. It's actually.
Hi, good afternoon. I'm Craig DeThomasis. It is 1:15, December 6, 2023. We are here in the matter of Preston and Hales, 38, 2023, DR 416. If I can just have Ms. Preston as the petitioner, if you could just announce your presence for the record, state your full name.
I'm LIEnette Preston.
Okay,
I'm
thank
here.
you. You may be seated.
I'm here.
Counsel.
Good afternoon, Judge. Randy Shockett Law Group, Trenton, Florida, on behalf of the respondent.
Sir, announce your presence.
Shock it like a law group.
Ma'am.
Martha Risk.
And are you co-counsel to Mr. Shockett?
No.
Okay.
No, he's not.
And what is your purpose in being here?
Your Honor, she's in addition to being a witness, she's also one of the persons protected by the order in Ohio that we ask you to take judicial
So
notice
what
of.
would be the relevance of her being protected? She can, if she feels like she's placing herself too close to the petitioner in this case and is at risk, she should sit in the back of the courtroom. If she's a witness, she should not be sitting at counsel table.
Okay. Well, then that's fine. Sit.
Okay, that's actually true. That's lawyers and parties, they get to sit at counsel table. If she's afraid, she should get farther away from crazy chick and sit somewhere in the back, near bailiffs or whatever. And if she's just there as a witness, it's arguable she shouldn't even be in the courtroom so that she can't hear what other testimony is being given and match her testimony to that. But Tortoise Queen hasn't asked for her to be excluded from the proceeding, so she gets to stay there. And he's just saying, look, just go on the other side of the fence. Like literally, she can just hop right back over there and go 1 row back. So yeah, that's just, he's absolutely correct. She shouldn't be there. She should just go 1 row back, and it's no harm, no foul.
Right back here.
Oh, fine. Well, JLMs, no spoilers. Of course, I know that already. 5 hearings in, still nothing from Jeremy's side. Thank you so much. An unknown hero, Judge Grudge. Grudge Judge just sounds weird. It's got to be Judge Grudge. Tell Megan to stop calling him Grudge Judge. It's Judge Grudge. He's a superhero. I'm sorry, he's a supervillain. Like Judge Dredd, but he's like an evil guy. Judge Grudge. Looking like George Carlin here. No, he's an aging Gallagher. He's an aging Gallagher who like smashes walnuts and cherries with his gavel. And so that's my story, and I'm sticking to it. Do they usually ask whom everyone at the table is like that? Yeah. Everybody, if you watch just about any trial, that's the first thing they'll do. It's usually the lead attorney or the lead lawyer will stand up and introduce everybody at his table or her table. But yeah, everybody gets announced. Everybody everybody has to tell the judge who they are and why they're there, basically. All right, let's go.
So we're here on several matters. The first thing I want to confirm here, hang on a second, pull up the case.
Pull up the case. I am going to do something here.
All right, so we're here pursuant to several matters of process. On November 29, an evidentiary hearing, an adjudicatory hearing was scheduled on the petitioner's
There, how's that? That's cool, isn't it?
affidavit, supplemental affidavit in support of petition for injunction for protection against stalking filed October 30th, along with the initial petition for injunction for protection against stalking filed September 7th. The case proceeded to hearing on November 29.
Okay, everybody wants me to speed it up. Should we speed it up? Oh, and you'll notice my tag is stripping for the Lord, because that's what she does. Yes, a stripper and a preacher. All right, looks like people want us to speed this up a little bit. So, all right, we'll do that. Sorry, people. We'll speed this one up a bit for you. Playback speed. We'll start at 1.25. If we start at if we do 1.5, then I'll finish too quickly. That's what she said.
Phrasing.
Right.
At which time it became apparent to this court at or about 4:45 p.m. that the petitioner was not yet concluded in her presentation of her case in chief. The case involved and included video footage, documentary evidence, and lengthy testimony of a pro se litigant that was not completed.
Hang on.
And certainly in consideration of allowing the petitioner to conclude presentation of her case, and likewise providing the respondent and his counsel at that time opportunity to be heard in opposition, including but not limited to cross-examination of the petitioner and presentation of evidence, either in the form of testimony and or other physical evidence, which could include videos, photographs, and
well, that wasn't a good decision, was it?
At least two witnesses that were identified as being present in the courtroom. Bottom line is, it became apparent to this court that there was no way the case was going to conclude by the close of business, and the court expressed in that record will reflect concerns for court officials and not wanting to cut the matter short. As a result of that, the court made inquiry and announced that the court would, in fact, clear the court's calendar for the following morning, November 30 at 9 a.m. to conclude these proceedings, balancing the need to adjudicate the case on its merits, the concerns and issues of the petitioner, the fact that there was no temporary injunction in place at the time, the need for the respondent to get a resolution, which at times, which was inexplicable, characterized by his counsel at the time of, Judge, this will just take a few minutes, when at the same time, talking out of the other side of his mouth, he had two witnesses at least. He had a desire to cross-examine the petitioner. He raised
Well,
issues of.
Excuse me, Judge.
Does it matter to you? I think it was like a rhetorical question, or I don't know that he wanted it to be.
Excuse me, Judge. What the hell is that? Judges don't talk to lawyers like that. Lawyers don't talk to judges like that. He's essentially, for no reason whatsoever, calling Feathers a liar. Because he mentioned at the end of the first hearing that he could probably wrap it up in 15 minutes with a few questions to her. He didn't say he could wrap up the whole thing in 15 minutes. It was conditional, like her. It's like, we might be able to wrap this up in 15 minutes with a few questions to her. He said they had all these other witnesses and it would maybe take 30 minutes if I recall correctly, but regardless, you don't talk. There is no reason whatsoever to talk like the judge is about the lawyer.
It was inexplicable. The concerns and issues of the petitioner, the fact that there was no temporary injunction in place at the time, the need for the respondent to get a resolution, which at times, which was inexplicable, characterized by his counsel at the time of, Judge, this will just take a few minutes.
15 at least.
At the same time, talking out of the other side of his mouth. He had two witnesses at least. He had a desire to cross-examine the petitioner. He raised issues of.
Well, you know what? You didn't let him try, did you? You didn't give him the opportunity. Maybe he could have. You don't know. So if he just he's talking out of both sides of his mouth, crap like that, that's just uncalled for, nasty spitefulness. It's Judge should be ashamed of himself already.
Judge, does it matter to you? I think it was like a rhetorical question, or I don't know that he wanted it to be adjudicated, but nonetheless, the court did not. Judge, does it make any difference that the petition was not even sworn to? Which they said, yeah, all legal issues, all factual matters are important to the court if they need to be adjudicated. So I don't know what that meant, but nonetheless, the petition from.
It meant, should you dismiss it because she didn't file it properly? That's what it meant. Everybody knows that's what it meant. He wasn't attacking you, Judge. This judge got butthurt for some reason that I cannot wrap my head around. He just said, I can cross-examine her for 15 minutes and we might be able to resolve this. I've got two other witnesses. If we can take those, and I believe he said it could take about 30 minutes total. He's like, I'm not going to keep my staff here for 30 more minutes. And when he was saying, how can you possibly do this in 15 minutes? I think that was one of the points he raised. She didn't sign it. He's like, well, does it matter if she didn't swear to the document like she should have? And the judge said, well, yeah, it might matter. So let him question her. And I would assume the questions would be something like, did you file this? Did you sign it? Are you supposed to? You didn't? All right. This is incomprehensible to me. That should be that's something you can easily deal with in 15 minutes. And as he said, that might just completely remove this whole thing. That would get it totally right. Did you do this thing you're legally required to do? Did you swear to the document that you're supposed to swear to? No. All right. Judge, we move to dismiss this thing because it is legally flawed. And he should be under an obligation to dismiss it because it is legally deficient. That's it. Easily done in 15 minutes. And if for some reason the judge didn't dismiss it, he's got a couple of other witnesses that would take 30 minutes. So this judge is not only is he butthurt and really shit talking the lawyer for zero reason whatsoever. He's twisting the facts. He's twisting what was said.
September 7, 2023, which is at issue, was sworn to before a deputy clerk of court. The supplemental petition filed October 30th, 2023, was sworn to before a deputy clerk of court. The petitioner herself on November 29 at 3:09:32 seconds was sworn by the court. And so, once again, inexplicably, I don't know what he was talking about, but it became moot. Doesn't mean that it's not relevant or remains moot, but it's in that context that Mr. Shot, you were.
See, I don't know what he's talking about. That's a bullshit statement. That's just condescending crap. What any normal judge would do if he wanted to take it up at this point would be, counsel, could you clarify what you meant by that? And then what he said, go, okay, here's the record of when she swore to these documents. Does that take care of it? That's all he had to do. Was very calmly, very nicely, very professionally just say, counsel, I wasn't quite sure what you were referring to at the end of that. Can you briefly explain the relevance or what it is you were talking about? That's all. I don't know what he's talking about. He's talking out of both sides of his mouth, and he's doing this. I don't know what he's getting at. What a dick! What just what an unmitigated dick.
Here, but counsel for Mr. Hales at the time represented. We could resolve this in minutes.
Yeah.
And in the history of jurisprudence, I don't know of anyone that's ever cross-examined a petitioner who presented 2 hours of testimony, confronted video evidence, documentary evidence, possibly presenting his own client. The court expressed under 9615 an intent to possibly ask the respondent several questions and present 2 other witnesses, all of which would be subject to.
Dude, that's not what he said.
Minutes.
That is not what he said, and you damn well know it. That's just wrong. Try again, dickweed.
Thousands of minutes, maybe.
And so, yeah, and so the relevance of the court setting this record is what we now need to address here this afternoon. On November 29, at the close of business, that Wednesday, the court offered that we will reconvene the following morning at 9 a.m.
Mm-hmm.
Just a second. I've got so many documents, I don't know. I'll deal with this first. So at that time, the court mentioned we'll reconvene at 9 a.m. The
Yes.
petitioner mentioned to the court that despite having a medical appointment for the following morning, she would change that or reschedule that appointment for the purposes of proceeding with the matters to be adjudicated that following morning. And so, not being insensitive to the fact that she would have to reschedule, the court accepted her representation. She could be here, was willing to be here, she would reschedule. When turning to the respondent and his counsel, what was represented to the court was, one, that the respondent himself, and the language was to the effect of he had to be present in Ohio the following morning to address matters relevant to those being considered by this court, that he had a flight out and needed to be in Ohio tomorrow morning, having to address matters in Ohio related to this situation.
Yep. So what?
And so that representation was made and considered by the court. In addition, counsel at that time for the respondent stated, and another thing, in effect, Judge, I've got a calendar conflict for tomorrow morning. Again, this court is obligated to consider the potential impact on continuance to the petitioner without having a temporary injunction in place. Nonetheless, the court at that time stated we would reconvene today's date, December 6, 2023 at 1 p.m.
Okay.
Counsel for Mr. Hales was present, did not object to scheduling it for today at 1 o'clock, agreed to schedule it for today at 1 o'clock. His assistant, who I'm familiar with, was present with him. And again, I didn't ask them this, but it would not be too presumptuous to think that the lawyer should know what his calendar is. When I suggested the next day at 9 in the morning, he didn't tell me what his calendar conflict, nor did I inquire, but he said he had.
Why is he being a dick about this? Why is he being a dick? I'm honestly wondering. Why is he being a dick? He's just yelling into space. Okay, we know he said this stuff. We know all of this. But he's like, just his ass cheeks are chapped about something.
Had one when I said, okay, next Wednesday, 1 o'clock, no objection, actual agreement to scheduling it. His assistant, again, I don't know that she would have done this, but it wouldn't be a far stretch to think two heads thinking better than one would say, hey, you got a calendar conflict. Take a peek at your calendar, or hey, take a moment, which I would have absolutely provided to him. Bottom line is, everyone was in agreement that today at 1 o'clock we'd hear this matter.
Okay, what's the problem?
Subsequently,
You're all there.
At 5:56 p.m. on a Friday, Mr. Feather, then counsel for Mr. Hales, files a motion to continue. The close of business on a Friday effectively becomes Monday as a practical matter, effectively becomes 48 hours or so before the start of this hearing. And the motion to continue, and at great length, this court entered an order denying the motion to continue on December 4. That motion to continue on its face was insufficient to grant the relief being requested. Number two, made no representation or no averment or no position stated with regards to what the petitioner's position might be, or that contact was made to see if she objects or not. Did not suggest when it might be continued to, if the court did continue it, and generally failed to establish any good cause for the requested continuance. Additionally, on the 29th, at the close of the proceedings, when the court directed and suggested and got agreement from counsel that we'd be here at 1 o'clock.
All right, now I don't have the documents here, but he said there's no meaningful basis whatsoever for giving a continuance. I'm sure the lawyer put in at least some reason. He wouldn't just go, we asked for a continuance, and submit that in like one sentence. There would have to be some support. There would have to be some explanation. So I'm calling BS on the judge here. I'm calling BS.
12-6 to hear this matter. The court also provided an admonition to everybody, to all parties. And the court said to respondent's counsel, in the presence of his assistant, to his client, to the petitioner, the hearing will take place on 12/6 at 1 p.m. If any calendar conflict arises, you'll have a week to take care of it by rescheduling whatever matter comes up that would otherwise potentially be in conflict, and made it really clear this takes priority. These types of cases take priority. This particular case takes priority. This is a case we already started. This is a case that could have been concluded the following morning. This is a case that the respondent and his counsel wanted a continuance. They were granted that continuance. They don't object to the continuance. They agreed to the continuance.
Well, that's not exactly accurate, is it? That's not exactly accurate. They said they had the scheduling conflict the following day. And I will say that the Feathers didn't explicitly agree to December 6th. But he also didn't object to it. He didn't object. And if you're calendaring something like that, I can very easily see why the judge would take silence, the lack of any objection to that date, as being acceptance of that date. Because that would be the natural thing to do, is go, I'm sorry, I can't make December 6th because I've got this other commitment, or my client can't make December 6th because I got this other commitment. So taking silence as acceptance, I understand that. However, the question is whether or not Feathers heard him. See, that's what I'm saying, back to country. Just let me finish my thought before you all caps at me. Just let me finish the thought before you start all capsing at me. We'll all get through this together. That's what I'm saying. There is some question in my mind as to whether or not he heard him, because he was standing in front of the table with his back to the judge talking to Jeremy. And I don't think the court gave him enough time to respond. So I find it very, very arguable. Very, very arguable that it was agreed to. What I would take a little bit of exception to is waiting until closing time on Friday before the Monday hearing, or whatever day of the week it was, waiting until the last minute to file for the extension. As soon as you get service of the new date, or you take notice of the first day, you go, oh crap, we need an extension. But I'm sure there's going to be an explanation for that. I'm sure there's going to be some explanation for that. But as it stands now, I would say it's equally arguable that his silence was consent to the date, and equally that he just didn't hear it and didn't consent. But regardless of which of those things it is, it's not something to go on for. We're going on like 6 or 7 minutes now. He's been harping on this damn agreement, this damn consent.
And then they're asking for another continuance. Inexplicable, without good cause, it was denied. In addition to that, the court and Mr. Hales, you might have said one or two things. I don't know. You weren't presented yet as a witness. Your lawyer.
Because you wouldn't let him. You wouldn't stop talking, and you wouldn't stop that cow bag over there from flapping her literally flapping her gums. Well, she's got 2 teeth. I mean, flapping her gums and 2 teeth. You didn't shut her up. You didn't let him talk. So, that's why he didn't say anything.
Represented to this court certain things on your behalf. And I have to accept those. I didn't question those, but you may be thinking, well, now he's questioning because in the order denying the motion to continue, I further directed the respondent to present proof of travel and his appearance in court in Ohio. Because quite frankly, that became the basis of the continuance. And in part, and we're going to get to in a moment, we're now dealing with a second successive motion to continue filed by present counsel, Mr. Shockett, who's here, on different grounds, but we'll get to that in a minute. But in part, because we now have that, it becomes even that much more important that the compliance issue is addressed. And the court asked for 3 things in that order. And the court has not yet received compliance.
From who?
The court asked for 1, written documentary proof of the travel itinerary corroborating that he did travel by plane to Ohio, to be present in time for a hearing on the morning of 11/30/23, and if it wasn't for a hearing, whatever, to present written documentation confirming and corroborating that he did in fact have a required court appearance in Ohio, scheduled for the morning of 11/30/23, and 3, that he attended such proceeding. What has now been provided to the court, styled as, quote, notice of compliance with court's order dated December 4, 2023, is inadequate, insufficient, and does not respond fully to the.
Okay, here's the judge being petty. You couldn't make it the next day. So we set it for December 6th. Now you want to change December 6th. How do I know you were really not available the next morning? So I want to see proof. I want to see proof that you were supposed to be there, proof that you went there, and proof that you attended. That I want to see all this proof. And now he's just saying whatever you submitted isn't proof enough. This is just being a petty little bitch. To her defense, tortoises don't have teeth either. She's just transitioning. Oh no, it's happening with Harper. Yeah, this judge is just being a petty, whiny little bitch. And he's going on, again, like 8 or 9 minutes now on this December 6th date. This thing could have been over by now if he would have shut up at the end of the last hearing and just hit the ground running today. He's got his panties in a twist, and he's going to untwist them here in court no matter how long it takes.
The order directing proof of compliance. What has been provided appears to be a copy of a boarding pass showing a November 30th, 10 a.m. flight from Tampa to Cleveland, and a return boarding pass from Cleveland to Tampa.
How is that not proof? How the hell is a boarding pass insufficient to prove he went there? Okay, he went. That would prove that he went there. I guess he's going to say, well, it doesn't prove he had to be there in court.
On December 3rd. And so the first issue that we need to resolve here is whether or not Mr. Hales has provided the court with the compliance pursuant to that.
Oh my
order.
God.
And my intent is to ask several questions to get that resolved so we can proceed with the other matters. Mr. Hales.
Why do you? Oh, come on. He's putting him under oath to ask him whether or not he had to travel that day because your butt hurt because he asked for it. This is all because he asked for an extension. He asks for an extension, and this is the result. All of this weird butt hurt shit where he's like questioning whether or not he had to go there. Okay, you went there, but well, now you got to prove that you had to be there. He's putting him under oath, and he's going to question him on this shit. Judge, oh my Lord. Oh, now here's an interesting thing. This is just a total side. This is a law racks and chat sidebar here. We're gonna put the judge aside. It's just you and me talking on sidebar here. I'm working on something because I learned something yesterday that I didn't know. Apparently, he is or was. I mean, I know he was. Maybe he still is the judge, an adjunct law professor. I didn't know this until yesterday. Another thing I didn't know until yesterday is that one of my personal friends went to the law school he was teaching at. So I'm talking with my friend to see if one of my I'm talking to my friend to see if my friend wants to come on and tell us some stories about the judge. I'll keep you posted how that goes. So yeah, that's just a little tidbit I wanted to throw out there. Because I got a text from one of my friends that said, "What's all this about?" This dude was a law professor at my school and a few other things. And I'm like, hey, you want to burn some bridges? So we're talking about it. So, well, if that happens, I will absolutely let you know. If it happens, I'm targeting early next week. So there you go. I think you'll all like it. I'm going to desperately try to get that done because I thought it was hilarious. So, all right, let's continue.
Your Honor, real quick, may I be heard on that just to give you an introduction before we do this? Because I just got some information from his Ohio lawyer I think is relevant. Okay, may I be heard?
Sure.
Okay.
Sure.
So thank you.
Thank
And
you.
I appreciate your getting me up to speed about what happened.
Oh my God, I hit the wrong damn button. God damn it.
And generally fail to establish any good cause for the agree to the continuance, and then they're asking for another continuance. They're directed the respondent to present proof of travel and his appearance in court in Ohio.
Where were we?
Because quite frankly, that became the basis of the continuance.
Where were we?
Continuance. They were granted that continuance. They don't object to the continuance. They agree to the continuance. And was in the order denying the motion to continue, I further directed the respondent.
All right, we're past that.
December
I'm so
4th,
sorry.
2023.
Wait for him to put. All right, this is where we were. I apologize. Of all of the real estate I can click on here, so it doesn't do that. I happen to like click on exactly the 1 millimeter of space that I shouldn't have clicked on. So all right, let's get back with this. I don't understand this.
Give you an introduction before we do this because I just got some information from his Ohio lawyer I think is relevant. Okay, may I be heard?
Sure.
Okay. So thank you, and I appreciate your giving me up to speed about what happened. I haven't talked to Mr. Feather, but what I understand from him, it was a misunderstanding about a hearing in court that morning. He went to his lawyer, and this is what I wanted, which I just got by email from his lawyer.
So this is the new lawyer. That is clearly, I can't see very well because it's really small here on my screen as far away. So this is not Feather, clearly, because that's not Feather's voice. And my understanding is that from the motion we just read, where it was accusing Feathers essentially of bribing her, or attempting to bribe her, he had to vacate his position as lead counsel, and they got a new lawyer in who immediately filed for an extension in order to get up to speed. This is one of the most common reasons for an extension. You get a new lawyer. I guess I shouldn't say getting a new lawyer is one of the most common things, but when you get a new lawyer, like literally one of the first things that that happens in almost every situation is that lawyer files a motion for a continuance to give him a little bit of extra time to get up to speed on the case. And unless it's purposely a stall tactic to delay the proceedings unnecessarily, virtually always the courts will grant the motion.
Him had us draft and sign affidavits which had been notarized in Ohio, and I've got them here, which were signed in Ohio on, it related to the injunction hearing in Ohio. They were signed on December 1st, 2022. Yeah?
Sure.
Okay. So there's one for Jonathan.
Now, this is an interesting thing. He was, I guess, according to what his lawyer was saying, he was supposed to go to Ohio to get some notarizations done. They had to be notarized in Ohio. Well, some of us, I guess, maybe, I don't know how many of you know, but there are online notaries where you can, go through an online system, say in a certain state, and get a notary from that state online without actually physically going to that state. But I seem to remember potentially criminal Sean saying that Ohio doesn't allow online e-notaries. So if my understanding of what potentially criminal Sean said that about them not allowing these online e-notaries, then he would have had to go there to get it notarized.
One for LIEnette. I just got these by email. It's one for this lawyer. Asking the same questions.
Oh, JKD Buck, thank you. I didn't mishear. I know things.
Can I object to this? Since it's not truthful.
Oh, shut up, bitch.
I'll get to you in just a second. Let me see what it is.
It's not truthful. 680 of you here, 415 likes. Let's get those likes up to 600. Come on, peeps. While the judge is futzing around up here.
Mr. Hales, if you can raise your right hand. Solemnly swear or affirm the testimony about to give in this cause will be the truth, whole truth, and nothing but the truth.
I do.
You are Jeremy Hales, the respondent in this action.
Yes.
You were present in court on November 29 when your counsel represented that you had to be in court the following morning in Ohio.
I was in court. I apologize. I was in court. My lawyer did not say verbatim I had to be in a trial in Ohio. He said that I
didn't say the word trial either. If that's
or
what you
in
heard,
court,
or if I
you might-
misspoke,
Wait.
it's not. I didn't say trial.
In court.
My legal counsel did not state I needed to be in court. He stated that I needed to be in Ohio to take care of things with the court.
Yep, that's
Having
what
to
he said.
address matters in Ohio related to the situation.
Yes.
Correct.
So did you or did you not have a court appearance?
I did not have a court appearance,
Nope.
nor was it stated that I had a court appearance.
Okay.
Correct, Jeremy.
And so what was it? You had to go there to sign some documents? That's what's been presented to the court?
Yes, sir.
Okay, so the court is familiar with, because the court does this on a daily basis, sometimes dozens of times, sometimes hundreds of times a day, which is signing documents from anywhere on the planet.
Yeah, I just told you can't do that from Ohio, biatch. Heh, heh, heh. I told you couldn't do that. You got to listen to me, Judge. You make yourself look stupid. Even I know that, and I'm a Utah lawyer living in Korea.
Gotcha, bitch.
Why did you
I'm
have
smart.
to go to Ohio to sign your name to a document?
Filing for contempt of court on the civil protection orders in Ohio, my legal counsel asked if I would fly and come and notarize and file in the court system.
That's not responsive to my question. My question is, why would you have to physically be there in Ohio to sign a document that could be signed in many, many other ways without you physically being present in Ohio to sign it?
My legal counsel in Ohio said I need to be in person to sign the documents.
Who's
There
your
you
legal
go.
counsel?
Eli Heller.
Eli, last name?
Heller.
Heller?
Yep.
Yes.
Where is the office?
In Cuyahoga Falls, Ohio.
So you're saying your lawyer gave you advice, by the way, anything you're talking about in terms of advice of your counsel, if you're choosing to talk about, because I'm not asking you to waive any attorney-client privilege, but you're raising as a defense to your non-compliance with this court's order that your lawyer told you had to be there to sign documents,
Yes.
which could you tell me, if you have a basis, why, from your perspective or from what you know about your need to be there, what was your need to be there? As opposed to
Judge, you're an ignorant ass. See, he's trying to pressure him into admitting he's lying. Oh, your lawyer said that? Your lawyer gave you this advice? Who's your lawyer? I'm going to check up with your lawyer. What possible reason could your lawyer have to say you had to be there? Because that's the fucking law? How about that, judge? How about that? See, the judge is just being a grade A government certified prick right here. The judge is dead ass wrong as far as I understand this. That you can't do the notaries. JKD Buck says his office is there. And he confirms potentially criminal Sean, an Ohio lawyer, I believe said that they don't recognize it, which is why it's kind of fun to make people come there and notarize documents. It's an inconvenient pain in the ass. So this judge is trying to trip him up, pressure him, guilt him into doing whatever. Oh my Lord, judge, you're being a dick. And this trial could be over by now. This hearing could be over.
To all other
But you're
forms
fucking
of the
around.
ability to sign a document from literally anywhere on the planet these days.
From my understanding, notarization in person with my lawyer and then filing in the Ohio courts.
Why couldn't you use a notary here in Florida with your lawyer here in Florida?
I did not ask that question, Your Honor.
So you're unaware of whether you could have done it that way.
I am unaware.
He followed advice of
Why is it
counsel.
not signed until December 1st?
My flight was booked prearranged for the date that you've been provided, and then the meetings were already set per date as well.
The meetings were December 1st?
Yes, sir.
So you did not have to be in Ohio on November 30th at 9 a.m.
So I had to be at the Tampa airport for my flight at 9 a.m. So no, I did not need to be in Ohio at 9 a.m. I needed to be at the Tampa airport at 9 a.m.
Walking a little close to
So
the
your
line
lawyer's
there.
representation that you need to be in Ohio tomorrow morning, that was stated to this court at or about 4:45 to 5 p.m. on 11/29. So tomorrow morning would be the a.m. of 11:30. You're stating under oath to this court, you did not physically have to be there in Ohio on the morning of November 30th.
What?
Your Honor, I had tickets pre-purchased. So to make my flight for my appearances in Ohio, there would not have, don't believe there would have been another opportunity to actually fly into Ohio to be able to make my appearances on
The lawyer
time.
never used those words and said, well, Judge, just to be accurate and just to be truthful and just to articulate our basis for asking for a continuance of a case that involves a petition for protection against stalking, for which there's no temporary injunction, so that you have all the facts and circumstances. Let me tell you, my client doesn't have to be there tomorrow morning, but for the fact that he's already paid for a ticket that will allow him to get there the day before he has to be there to sign a document. And maybe the court at that time could have inquired of counsel. Counsel, could you tell me, just hypothetically, why would somebody have to physically be in Ohio to sign a document? Right? That never took place. And I know that because I've reviewed the hearing half a dozen times, and I was the one who was presiding over the hearing. What was represented to this court by your lawyer is that you had to be in Ohio tomorrow morning, which would have been November 30th, a.m. Having to address, when lawyers use that word, has to, must, shall, requirement, be in Ohio related to the situation. And what I'm now hearing is you really didn't have to be there till the next day. It may be that you really didn't have to be there at all because all what you did was sign a document, not.
Judge, pull your undies out of your ass crack, man. Relax. Holy crap. This is absolutely uncalled for. This is absolutely uncalled for. This judge is just going off. He's venting. He got butt hurt, and now he's trying to find ways to take it out on the lawyer and on Jeremy. Why is the judge being an ass? That's the question. That's why I'm involved in all of this what the hell stuff, because people were talking about how horrible this judge was, and then for those of you that don't know the backstory of how I became involved in this couple of weeks, last week, was Larry, DUI guy, posted something on Twitter with some judge, berating his answering service or his secretary, whichever one it was, saying he's gonna file a law complaint against a DUI guy, and you better buckle up. And I thought, well, that's just an asshole thing for a judge to say. That's just a dickish thing for any sitting judge to say to a lawyer. And I said, if that was really a judge, And if even if that was really a lawyer, it was absolutely uncalled for and is unprofessional. Turned out it's this guy. And I'm like, all right, what's getting all involved in this? And I started watching a few things. I went, all right, this is nuts. I've got to find out what the hell's going on for me. And that's how I got involved in all this bull crap. And so, yeah, and I watched the first part of the first hearing, and then I watched the first hearing again. And I was thinking, this guy seems like a pretty normal guy. Where does it go off the rails? And it went off the rails basically the last 20 minutes of the first hearing. Jill M says, look at LIEnette. She's on her phone. Yeah, she seems to be there over on her phone, just scrolling away while he's on the phone. But thank you so much, Jill, for the super chat. So this is really ridiculous that this lawyer's doing this. I mean, this judge is doing this. He's just butthurt because they asked for an extension. All of this is because they asked for an extension, which is a very normal thing to ask for when you swap out lawyers, when you get a new lawyer just a couple of days before the hearing. And he's gone on for damn near 12, 13 minutes about this date.
See a judge who required you to make a court appearance.
Judge, may I ask some questions?
In a moment, you can. Is that accurate, Mr.
I'm
Hales?
not done yelling.
Is that the more accurate representation?
I think the accurate representation is there is a scheduling conflict. And on my part, a very important scheduling conflict to be able to catch my flight, to be able to go to the sheriff's station, to pick up my certified civil protection orders against LIEnette Preston and John Cook, because they cannot be served to anybody else. I had to be in Ohio in person at Summit County Sheriff to receive those, then to go to see my lawyer.
Why did you have to get served with something?
Because that's the way the system works. I'm served as well. She's served, he's served, I'm served.
The
Are you
issue is
really a
on
judge?
November 30th in the morning, you did not need to be there to be served. You did not, now we know, need to be there to sign any documents. Because it doesn't even take place till the December 1st date.
No, sir. The issue is I had a scheduled flight to be there and do not believe I could have gotten another flight to be there on time.
Did you ever set your lawyer straight when he was standing in front of this court saying that you had to address matters in Ohio tomorrow morning related to this situation?
I have discussed this with my representation, yes.
He stood in court. You were standing right next to him. We're sitting right next to him where he said nothing about.
Oh my God, Judge, shut up. Seriously, just shut the F up. He's berating for this technicality. It was a misunderstanding, clearly a misunderstanding. I don't think it was an intentional misrepresentation. It didn't sound like it to me. It's a misunderstanding, a slight miscommunication that you go, okay, my bad, sorry. But he's trying to nail Hale's ass to the wall on this, just pounding him, just pounding and pounding and pounding on him. Meanwhile, he lets this nut job, Tortoise Queen, ramble on for 2 damn hours, spouting absolute nonsense without batting an eyelash or saying a word. I'm flabbergasted.
And it might cost him an inconvenience. And I would have considered that. There's no doubt that I would have. It wouldn't have been a problem. I would have also inquired, like I am now, tell me how, because I don't know of any law that requires you to physically be present in another state when you can sign it here. We have plenty of notaries. You could swear before me. You could have sworn.
Are you an Ohio lawyer? Are you an Ohio judge? Do you have any fucking clue what you're talking about for the state of Ohio?
Whether that process could have been available to you to accommodate you and save you from going to Ohio and back to Florida.
You
My
can't.
concern is your lawyer was misrepresenting something to the court.
Well, oh God damn it. He's railing on Jeremy Hales for Jeremy following his lawyer's advice, for following the advice of counsel from his Ohio lawyer. And now he's taken this poor new lawyer is just sitting there going, what did I didn't do anything. I just filed a motion for an extension. And then he's yelling at Jeremy saying, you should have stood up in court and you should have immediately corrected your lawyer. That's hogwash.
And got away with it with a continuance to today. And what's relevant about that, aside from the issues with the lawyer, is that we're now here today with another lawyer asking for another continuance. Which is putting you in a jam. I've got to be concerned about your ability to present your case because I've got to decide this case.
Holy shit snacks. I'm concerned about your ability to present your case because you just seem like you're trying to get all these delays because you don't have a case. Meanwhile, what did he do with her in the first hearing? She can't bring any witnesses because of their public documents were out in public places as part of public proceedings. So her all of her witnesses can't come. Her only remaining witness, he can't come because he's out in the car with her daughter who's suffering from life-threatening metabolic illnesses, and they have to stay out in the car for some reason. So he can't come in. She's got all of these videos on a thumb drive, but they can't be shown in court. They can't be played for some reason. She's the one that is fucking around and can't present her case. Not once did he say to her, I'm concerned about your ability to present your case. You don't have any of your documents here. We can't see any of the videos. All of your witnesses are gone. The only witness that's here in person is out in the parking lot for some reason, because that's where he's got to sit. Not once did he say anything even remotely similar to that to her. But yet she's jumping his ass. He's jumping his ass for this stupid tiny little thing. Good Lord.
For the interests of both of you. And the lawyering is standing in the way to some extent of that.
Oh, shit.
Now I haven't gotten to the next motion to continue. We're going to get to it in a second. The court makes a finding that there is non-compliance with this court's order dated December 4, 2023, which included the language that there were requirements to establish proof of the travel itinerary, that he did travel by plane to Ohio in time for hearing on the morning of 12/1, to corroborate that he did appear and that he was required to be there, when we now know that's not exactly what it was, nor would it have been if properly, truthfully represented to the court. And I'm not saying, Mr. Hales, it's all on you, but you're sitting there while your lawyer is representing to this court and misleading the court, and nothing was done to prevent it. And nonetheless, what's relevant for today is that bought you a continuance. And now you're asking for another one. And I'm going to hear from Mr. Shockett in a moment about this next continuance. So as of now, there's non-compliance with the court's prior order.
Wow.
Largely in part on the misrepresentations and the less than candid representations made to this tribunal on November 29.
That's horseshit, Judge. That's an even bigger misrepresentation of what happened
today. The context, again, is significant because the nature of this case, the nature of the pleadings, the nature of the issues that arise, the fact that it involves allegations and averments of long-term behavior, that it included the presentation of multiple videotape items of evidentiary value, documentary evidence,
which we couldn't show for some reason last time, which weren't there.
A pro se petitioner who had
it's her own fucking fault.
Case in chief, that we had a petition, a supplemental petition, which were separate pleadings. Each of them were fairly lengthy. The court at the time of the hearing on November 29th also made comment to counsel, and I don't have any indication that counsel was actually aware of what the court was even talking about. Maybe he was, but that there was a statutory change in October of 2021. But since the statutory change, there's really has been no appellate court decision addressing these facts in light of the statutory change. That the case precedent prior to the statutory change that addressed a very similar fact pattern, which I mentioned to counsel, Strober versus Harris, decided January 5, 2022 by the 2nd DCA, 332 Southern 3rd, 1079, said in part, relevant part, that it reversed that court's determination that there was not a basis for a stalking injunction, and said that a crucial part of the statutory definition that the court conspicuously failed to address was the issue of posting, that's what that case was all about, publicly posted videos. And on the phrase in the statute, caused threats to be communicated, that the court in Strober at the trial court level failed to address that. And so the DCA was sending it back. And in footnote number 1, pointed out, by the way, there's been a statutory change, House Bill 921. We can find, the 2nd DCA was saying this, we can find our analysis to the prior version because that was in effect at the time of that case. And did not comment on which version would apply upon remand. They left that issue open. Clearly, this case, this petition and supplemental petition were filed after the operative date, the effective date of the legislation that changed things.
People, I'm going to have to be a terrible host, and I've only had to do this once or twice ever. I'm going to have to put a little interlude music on here and take care of a little bit of a mess here that the two bulldogs made. They seem to have gotten into my travel bag and have chewed on my toothbrush, my travel toothbrush, and seem to have consumed a container of hand cream. I need to clean this up real quick. I'm just going to put on some very quick musical interlude here, and I will be right back as soon as I prevent them from doing any more damage. Give me 1 minute-ish or less. I apologize profusely. Nobody go anywhere. I'm going to be right back. This is stupid. All right. Give me a second.
Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Mauryan Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been recorded. Find me one that won. God dang, you're right. Don't go down this. It's not the...
Oh, anybody want a couple of brain dead dogs? I swear to God. I apologize for that. That's my bad. My lotion and my I kept like hearing something that sounded like something was vibrating, and I'm like, I don't have anything vibrating in my house. I'm a dude. I don't. and it was my toothbrush. I have like one of those vibrating toothbrushes. Yep. Well, we've lost the vibrating toothbrush. We've lost the super expensive hand cream. We've lost well, not really lost. It's just kind of icky, sticky, and gooey. Very expensive boar's head, like boar's hair mustache brush. But anyway, all right. Let's go. I apologize for that. Let's get back into this. But do we have super chats clear? Oh, we do. Jill M's is she has diarrhea of the mouth. Lol. Seriously, just can't get her to shut up. And he's the one. He hasn't said anything. There was one small miscommunication, and now he's getting pilloried for it. And Jill M's again. Thank you so much. It's Jill M's night here on Legal Vices on the Law Access channel. Excuse me. If Judge would shut up, court could have been done. Yeah, right. Absolutely. And Jill M's again. Thanks. Look at LIEnette is on her phone. Hey, we did that. She is over there just kind of scrolling around, being happy on her phone. I apologize for that break. And despite that weird interlude, Kilobytes has just become the newest member of the Clean and Sober crew. Thank you so much for joining the Clean and Sober crew. Kilobyte, we're glad to have you. And Island, thank you so much. Oh, Jill, wait, I just out of order here. Island, thank you so much. Don't disparage those angels. They're perfect potatoes. Yeah, with like the intelligence of potatoes as well. Hashtag innocent, hashtag justice for doggos. And Jill M's. For the final super chat before we move on. We're going to watch her deposition. Don't worry. Watch her deposition. She said her mother died. Lawyer said, what proof do you have? She then said, my mother didn't die. Yeah, we're great. We're going to be watching the deposition here. Probably could be over the weekend, could be early next week, but we'll get there. Thank you so much, Island and Jill M's, for those amazing, super wonderful super chats. I appreciate that, and thank you, Kilobyte for being our newest member. Let's go.
October of 2021, when the state legislature decided that the court needs to abide by in Florida statute 784.048 under subsection 1D1, the definition of cyberstalk, they included language. It states to engage in a course of conduct to communicate or cause to be communicated. And they added these words directly or indirectly. Then it went back to the previous words, which reads as follows: words, images, or language by or through the use of electronic mail or electronic communication directed at, and then the legislature added these words, or pertaining to a specific person. And so the addition of the 6 words, directly or indirectly, and or pertaining to, clearly redefine the analysis the court must employ to evaluate these facts in light of that statutory change. And to my understanding, and that's why I brought it to counsel's attention at the time, there's been no appellate court decision addressing that matter.
On the new statute.
Correct. So in that context, that's one of the many reasons along the other.
What are you doing, LIEnette?
It's a little different than your run of the mill. I handled probably 5 or 6 other injunction cases in the previous hour before I got to this one, which took 2 hours and is now clearly going to take longer than that. That being said, the court already covered the fact that I granted the continuance. It's clear to this court now that it was based on less than accurate.
Oh,
less than truthful
God, how many times are you going to say that?
being claimed for the continuance.
69,000 subs yet? No, we are 44 subs away from 69,000.
Why it should be continued. Again, the court gave an admonition to prior counsel that if you've got a calendar conflict, deal with that conflict, but changing whatever that other matter is or may be, because we're going to be here on December 6th at 1 o'clock. There's been an intervening development.
Yes, new lawyers.
That
That's a
certainly
big intervening factor.
may require another reevaluation, and that is subsequent to receipt of the after hours motion to continue that this court happened to see Monday morning when coming to work and addressing it. The court then receives what amounts to a second supplemental petition filed,
Which we just read. That's what we read at the
by
beginning.
petitioner, which did result in the temporary relief that was previously sought and denied at least 2, if not 3 other times. That being said, and counsel is aware, and Mr. Hales, I presume, is aware, but so that he is absolutely aware, I presume, because he's had now 2 lawyers represent him, that the court has to confine its analysis of a petition, accepting what's being alleged as being true. And if true, does it entitle the person for relief? The hearing then is to determine, is there competence in
Okay, that's interesting. That's the one thing we were talking about before, is what standard of proof has to be met in order to get this order, this protective order. And they're saying to get the temporary order, you have to assume anything that's written in there is true. And if it's true, does it rise to the level of seriousness that would serve as the basis for the protective order? So all of that stuff we read in anything she's put in the first injunction and in the first petition for the protective order, the judge by law has to presume that everything she said in there is true. And then to say, okay, if this is true, does that rise to the level of needing a protective order? Then they issue the temporary protective order. And at that point, the person who's the subject of the protective order can contest it and argue against it. And they'll have a hearing to see whether or not what was in the motion was actually factual, and if it actually did rise to the level of something needing protection from. Well, it is for says Bush McFadden says he has to presume everything she said is true, but not Jeremy. I think it's called bias. You have to be biased in favor of someone filing a petition for a protective order, because that's how people die. If you just say, "Oh well, I'm not sure if this is true," come back in a couple of weeks and bring me proof that you're being threatened, your life is being threatened, or you're the subject of domestic violence. You assume it's true. Then you give a temporary order, whether it's 2 weeks, or whether it's a month, Sometimes they'll put them in place for 6 months or a year, whatnot. The sort of the permanent ones, but usually it's for a few weeks or a month or so, and that's the time that the person has to go in and contest the protective order. And as long as we're stopped here, Krista, what's up? Krista's been a member for 12 months, a year. Love the content, Law Racks. Love all the videos. I have learned so much. All that. I'm sorry. I didn't try to educate anybody. It might accidentally happen though at times. Scory, £2 for the toothbrush fund. Thanks. Thank you so much. Appreciate that. And John Doe. They put the hand cream on their tongue. Then the toothbrush vibrations have begun. It puts the hose in the basket or the dog gets the lotion again. Something like that. Thank you everybody for the for the member chats and the super chats. Let's continue with this weirdness.
List, credibility questions, etc., to be determined. So we were partway through a case where I must have said on multiple occasions at the close of the case to Mr. Feather, I've only heard one side of the case and not even the entire side of that case. I don't
Because
want
she
to
wouldn't
deny,
stop
I have
talking.
no intention of denying the respondent's ability to present contrary evidence or contradict or confront the evidence being presented against him. And so one issue, and Mr. Shockett, I just got to ask, because there's a notice of appearance that's styled as notice of appearance as co-counsel. Then there's your motion filed 12/5/23 at 12:53 p.m., styled as an urgent motion for continuance that states under subsection 2, co-counsel Mr. Feather, so that's consistent with your notice of co-counsel, is not available on 12/6. But then it adds this phrase, more importantly, respondent wishes to have undersigned counsel represent him at the continued hearing. There's a couple ways to read that. One is he wants you and not Mr. Feather at the continued hearing, meaning today is the continued hearing, and you're here. So one way to read this is the respondent gets that which he wants, and which, quite frankly, from the court's perspective, he deserves his choice of counsel here at this continued hearing. But then it's a motion to continue. So I presume that when you say continued hearing, you're saying if I continue it to the next hearing.
Yeah. Okay.
And so that's one issue, because it would be presumptuous without any basis to be presumptuous that I guess the court's going to grant this continuance because we're asking for one. That would be a fallacious and strange hypothetical assumption to make without a basis. But that'd be one way to kind of look at this. But the other is if Mr. Hales wants you at the continued hearing to the exclusion of Mr. Feather, this court will analyze this situation differently than if really you're just co-counsel to Mr. Feather. Because if you're co-counsel to him, you then have the institutional knowledge he has. It's not like we get halfway through a trial or we get to the end of the trial and then somebody says, well, I've got the financial ability and wherewithal. I'm going to go hire another lawyer and say, I'm going to continue this case. I'm going to get another lawyer to start from scratch, rebuild my case, and maybe shore it up a little bit. I mean, I don't know where there's any precedent for such process. And I don't know that necessarily that's intended, but I don't know what's intended, nor am I questioning your involvement in the case, but I got to know what your status is.
Okay, thanks, Judge. Thank you. May it please the court. My status is to continue to represent him as lead counsel.
Got to slow it
in this
down.
case.
Sorry.
But that clarifies it. Here today, if we don't finish it, whatever happens going forward, and maybe Mr. Feather withdraws, I don't know. He is at a doctor's appointment, as I understand it, in Gainesville.
Well, here's another thing, and I don't want to be insensitive about this, okay? But under the circumstances of this case, Mr. Feather didn't plead on November 29th at about 5 p.m. He said, I can be there on December 6th at 1 o'clock. So if it was an emergency that came up from November 29 to today's date, medical intervention of necessity, etc., clearly the court would have waited a lot different than, oh, Judge, I've got an appointment on December 6th at 1:45 that I didn't tell you about, and it doesn't say when it was scheduled. Maybe after we scheduled this hearing, that would be ridiculously foolish to do. But I have no information to go on, and I'm not insensitive to life happening while court is happening. Okay, and so if he had a medical intervention of necessity,
I doubt that you would have done some bullshit.
I don't know about that. I don't know that it's good cause. I ruled it was not good cause. He could have replet it. He could have asked to provide additional information. And again, his motion and yours, and we'll get to yours in a moment here, doesn't say anything about his precedent's position on this. And so we've got to come here. And so I didn't deny or grant your motion. I didn't address your motion yesterday, even though I saw it yesterday, because I couldn't, because I've got to hear from the petitioner as well.
Totally understand.
And then in your motion, so you're saying that if the relief is granted and it's continued, you're going to present as lead counsel.
That's what
Yes.
Have you considered what you would do if the continuance is denied? Are you prepared to proceed today?
as best I can, given the limits, Judge. I just got hired yesterday. I had two
Of
hearings
course.
this morning. working within reasonable human hours. I looked at stuff last night, but woefully unprepared because in that short of time. And also,
Well, see, look, I mean, that's what is the judge getting at? Those are the two options. If he doesn't give the extension, if he doesn't give the continuance, they're going ahead today. If they do give the continuance, they're going ahead whenever it's scheduled. I don't know what he's harping on about this. It's like, oh yeah, well, you say you're going to be the lead counsel if it's extended, but what if it isn't? What are you going to do? Are you going to go ahead today? He's got no other options. If the judge says, screw it, you don't get an extension, we're going today, then he's got to go. That's what he's saying. I'm woefully prepared and I'll do my best with what I've got. I've only glanced at this, but if you say go, we got to go, Judge. That's all he's saying. He's being very nice about it. Whereas Judge continues to pontificate like a prick from the stand. Oh my gosh.
now we do have the temporary injunction in place, so there's no prejudice.
Which I said,
Yeah.
changes things a little bit.
Yeah.
So have you reviewed the proceedings from November 29th?
Not all of them, Judge. I don't have all the materials. I've asked for a transcript. We've ordered it rush basis, so I can see the. I do have one of those AI transcripts,
Right.
but I don't trust it because I can already see some misspellings. And as you know, the devil's always in the details. So I'm waiting for the official transcript to be
So-
prepared, and also the witnesses.
So here's the thing. I'm not asking you to disclose attorney-client communication. In fact, I'm specifically stating I don't intend to do that. That being said, so I can work on a presumption here, which is when Mr. Hales contacts you or you contact him, whatever, when you guys come into contact with each other about this pending matter, 12/6 at 1 p.m., you either had to tell him, I can be
Ladies and gentlemen,
prepared
Megan
despite the
Fox.
fact that I only have 25 hours notice, or you had to tell him,
No.
I could kind of
didn't.
try to be prepared, but I won't anyway near be as prepared as I could be or that I should be on your behalf. If I took I presume you had a conversation. I was in practice for 36 years representing people. You probably should have had a conversation. I don't want to be too presumptuous. If I get a continuance, I'll be much more prepared than I am able to do in 25 hours. And so the relevance of the question, depending on how that conversation, either Mr. Hales willfully, intentionally, purposefully hired a lawyer who he knew absolutely could not be prepared to resolve this issue today.
What evidence is there of that?
Or he hired a lawyer that he would know would not be prepared, hoping that would be grounds to continue this, rather than go and find a lawyer who says, man, it's a short period of time, but man, I can do what I'll do, and I'll be prepared. I'll take your case. So I'm not questioning you and saying I'm not even getting into this, but I got to question the motives of Mr. Hale in gaining a continuance, because a continuance is a victory for someone who doesn't have a temporary injunction. Precluding entry of an injunction
Correct.
is in their favor, clearly.
Right.
And to the detriment of the petitioner.
But I think at some time, well, first of all, there's more that happened in the meeting that I'm not allowed to.
Well, I
reveal.
don't want you unless you guys are willing to waive. I'm not saying that. So that's what I'm saying. You either, and I'm not saying that you are completely negligent in not telling your client, dude, you're hiring me and the hearing's 25 hours from now. How can I possibly be prepared? Or you said, I'm on the spot. I got it. I do this all the time. Whatever. It only implicates Mr. Hale's decision to retain a lawyer who now is in front of the court saying, I cannot effectively.
Yeah, Georgina
I
Archer,
want to be represented.
who's the one wasting the
You said,
court's
"I'll do
time.
this,
Yeah,
I
that'd
can,"
be the
and you
court.
will, but you're not saying, I'm going to provide him effective representation. No, there's no constitutional requirement of effective.
There is absolutely no reason whatsoever for this lecture. There's no reason at all that the judge should be lecturing the lawyer this way. That is literally the only two choices. He's going to get the continuance, he's going to get the extension, and the lawyer will prepare and deliver. If the judge says, no, we're going right now, the lawyer has no other options than to go with what he's got. And I'm sure his client knows that. He keeps repeating this same thing over and over again. His client knows this. And if he didn't, he knew it the first 15 times you just talked about it. And the lawyer certainly knows this. This is absolutely unnecessary.
Representation when it's counsel of your choice, and you knowingly hire somebody who tells you they can't be fully prepared, or it might be that you hire somebody who can't be so that you shore up your argument to continue it.
No.
So first of all, we have the protection in place here of the TO. We have that. And that did come to my attention yesterday. I think it posted online like within an hour after I filed the motion. I knew that this was relevant in weighing the prejudice to both sides. And I can tell you as an officer of the court that this is not a case of just continuing counsels and I'll be the lead counsel in this case. And so I think there's very legitimate grounds given.
All right, now he said, I can tell you as an officer of the court that we're not playing games with this, just getting lawyer after lawyer. Those are kind of magic words in the legal profession. When a lawyer says something as his client's representative, you know, it's when they say, look, as an officer of the court, that's essentially him swearing to the judge. I mean, he's putting his name, his reputation, and a whole bunch of other shit on the line when he says, look, as an officer of the court, I'm telling you what this is. That's a take me at my word because I'm not messing around and I'm not lying to you. So he's using almost lawyerly magical words saying that.
Here with the this helps tip the scales given this lack
Let me
of.
ask you another question. How do you plead under subsection 4 that the petitioner will not suffer any prejudice or inconvenience as a result of a continuance? How do you?
Well, it's a brief continuance, Judge. I don't think it's going to be any prejudice. And now,
Well, what's brief? Because that's
well, that's
another thing.
when's our call. I'll do it.
The motion doesn't ask for a particular period of time.
I don't have your. Well, I would say as soon as you want. I mean, within reason, give me 10 days to get prepared, and we'll be here in 10
Well,
days.
you know, I've been tempted to do this in the past, not with you, but with counsel that moves for continuance, but doesn't say how long. And I could have continued it from 1 o'clock to 1:30.
All right. Yeah.
I mean,
Well, see, then you'd just be an ass, wouldn't you? Well, you didn't ask for the time, so I could just do it for 30. I could give you a 30-minute continuance. What? Before? Why is he being so petty? See, this is the problem. I don't know. It's just something that's happened in my older age, and this judge is clearly way older than me. But I don't have time to be petty like this.
I don't know how
Yeah.
long you need.
Yeah. Right.
Right.
You want 20 days? I'll give you 20.
He told you I'm good to go. You tell me how many days and I'll be ready. Just, not today, please. 10 days will do it. 20 days will do it. I'm ready to go. You said it, Judge. You tell us. But the judge says, well, I can tell you 30 minutes from now. Oh,
Yeah,
my
that's
Lord.
So to say that there would be no prejudice or inconvenience, I mean, we know at a minimum the inconvenience is the petition was here on the 29th, agreed to be here on the 30th, despite the fact that she would reschedule her doctor's appointment, then agreed if it accommodates them, and Judge, you're saying we could do it on the 6th, I'll be here on the 6th. She's here on the 6th. So there's some inconvenience. And she'll have to come back again. I don't think that you filed this pleading when there was a temporary injunction in place.
I don't know what time was it?
Your filing is at 12:53 p.m.
On the 5th or the 4th?
on the 5th.
Well, this was filed on the 4th, Judge. Wasn't this one entered on the 4th? Or the 5th? I don't even know now. Entered on the 4th. This TRO.
And so your position is that if the court has the temporary in place, there's no prejudice.
Yes.
She's got the protection that she's seeking temporarily.
Yeah, and you can continue.
Yeah.
There's a day, 15 days. I think you can continue that if it gets continued. But yeah, the protections are in place.
With regards to inconvenience, why is it not inconvenient for her to have to come back?
She's won, Judge. She's won. She has her injunction.
Well, no, she's asking for a final, at the start of the
understand.
proceedings, I ask all petitioners, are you here asking for a final judgment?
Right. Which would adopt the same standards, the same restrictions against him. Just a question of how long it's for.
Well, it's not. And I guess that's going to get us to another issue, which we'll get to in a minute, which is if there's a temporary injunctive relief in place, it's going to have to include additional language than the general buffer zone language.
Okay.
And we can address that here in a second, but I guess you're not able to disclose to this court whether Mr. Hales intentionally, willfully retained counsel that could not be prepared.
There were other issues we discussed. I really don't feel, I'd like to say it, but I can't.
Okay, if you can't, that's fine.
It's more than just that.
There's at least the appearance of manipulation of the court to continue it, to either allow continued behaviors that are intended, to allow what came out in evidence was a financial incentive to continue certain behaviors, because it came out in evidence on November 29 that Mr. Hales makes a financial profit from the actions that Ms. Preston is claiming are causing her substantial emotional distress.
And she's met that burden, which is a higher burden without evidence here. And, she's basically.
What I'm saying is, on this point, is that the continuance could be to the benefit of Mr. Hales, while it's to the detriment of Ms. Preston,
I just.
because he's earning a living.
But he's prohibited from doing the acts that cause harm.
Oh,
So,
that's the part we need to be clear about.
okay, let's be
The
clear about
temporary
it. Yeah,
injunction.
sure.
Because I don't think the temporary standard injunction that was previously ordered necessarily includes that. And let me share with you something else, Mr. Shaka. And
Okay.
again, this is, I presume, outside of your control,
Go ahead.
which is part of what's pled in the second supplemental petition filed December.
I did see that supplemental petition.
Yeah, is that Hale's attorney, which is referencing Mr. Feather, has called making multiple offers of cash or proceeds from Mr.
That's why Feather's not here. That's why Feather's not the lead attorney, I'm guessing, is because this judge, as we talked about at the beginning, this judge told them, to between now and the time December 6th, when we have the next hearing, you guys get together and work it out. There was some question whether there was no question that the Ohio protective order prevented Hales from talking to Tortoise Queen directly. But there was also some question whether the Ohio order would also prevent Hales's lawyer from talking to her. But apparently they worked that out. And from what it seems like is his lawyer reached out to try to have a discussion with her about, okay, let's talk settlement. Is there an amount you want to settle for your, we'll give you something for your alleged damage if we'll just all go away. But she couched it in her December 4th application for her amended application for her protective order. She made it sound like he was trying to like bribe her or like coerce her or and I think that's what oh my lord, I think that's what he's talking about. Yeah.
Or telling his fans to leave me alone.
Twice now.
And hang on, and I say that, ma'am, I have to accept the words that you've pled as true. We're going to get to an evidentiary hearing about whether there's more or whatever, but that's what's pled.
Sorry.
And that's especially relevant because it was Mr. Feather when I suggested that, hey, this can't, at 444, 447, when I said this is not likely to finish here today, and he pushed back and I said, denied, it's being continued. There's good news and bad news. Bad news, you're going to have to come back. The not so bad news, I don't know if that's good, is maybe counsel for the respondent and the petitioner can communicate about working towards a resolution. And I said that in the context, and I kind of regret saying it, quite frankly, but I said it in the context of I've presided over hundreds, maybe thousands of these similar cases. And there are people, just like every other civil case, that can work towards a resolution. Clearly, Mr. Hales and Ms. Preston should not be the two people. And so I suggested maybe counsel can speak to, and it was Mr. Feather that said to the court, and hang on, I'll get this quote, that the language in the Ohio injunction that was already in place would not allow for such communication.
Yes, that's what I was just
From
mentioning.
his perspective, Ohio's law would consider it a violation. And I said, well, I don't understand that. I said, show me. He handed me a copy of the final judgment from Ohio. I read it and I said, I don't see here where contact between an attorney for the respondent having communication, working towards a resolution of a potential litigation in another matter, somewhat related, but another matter, would be a violation of Ms. Preston violating the terms of that Ohio. But that was the position taken by Mr. Feather. And I didn't absolve him of that. I didn't resolve that issue. I didn't give him any clear carte blanche. No, dude, it's cool. In fact, what I said to him is I said, if you need clarification on that so that it's not a violation from either perspective here, I'll call the judge in Ohio and we can always carve out an exception. I do it all the time with my colleagues in the criminal court. They have no contact. And then I have the same people in a divorce case.
The judge is having a moment of lucidity
and mediator and their lawyers present.
and normalness here.
We work out those deals all the time.
What, interstate? You've done interstate as well?
Yeah.
Okay.
Feather was the one that pointed out 741 point. Hang on, don't hold me to it, but 135 or whatever. I've got jurisdiction. I've got full faith and credit for their order.
Yes.
He actually said, and this is another thing contradicting. And I'm saying, Mr. Hales, I'm not saying you're contradicting what I'm about to say here, but your lawyer did, which is the lawyer was representing to me. Mr. Hales had to go up there to do something. I now know it's about dealing with some alleged violation, what have you. Feather was here in court saying, Judge, we anticipate. Word wasn't anticipate. I can pull up the exact word, but it was about we anticipate, we expect, something to that effect. Don't hold me to it. I don't have the transcript in front of me. The filing of a violation here in your court for Ms. Preston allegedly violating. I go, why would you be filing that here? And he brings up the statute and says, because we can. And I didn't contradict that. Okay. If and when you do so, we'll cross that bridge when we get to it, but we're not there yet. You anticipate it. You expect to do so, whatever. You haven't done so yet.
I think they did it today, Judge. I think they did it today.
Yeah, but it's Feather who says to me, this premise of speaking to Ms. Preston would be violating a court
He
order
didn't say
from a
would
judge
be. He
and/or
said
ma-
might be.
magistrate
He's
in the state of
concerned
Ohio.
that it
And
would.
then I get an allegation that I have to accept as true. It may not be ultimately when we get to an evidentiary hearing, but I have to accept it as true that he's contacted her and on multiple occasions offers her cash to drop this or to some way settle this. And that, on top of everything else I've already talked about exhaustively here, is very troubling, and has to be considered when we're considering continuing this thing even again. There is at least on the face of what's pled, and I know you're restricted in maybe not being able to say more, that there's a possibility that the motion to continue is manipulative at best. That being said, I've already said we could probably come up with conditions in addition to the general ones of the temporary that would satisfy this court, allow for Mr. Hales to have fully effective representation because of attaining a fully prepared lawyer, and giving Ms. Preston peace of mind between now and then, even if it's at the cost of what I consider slight, but still some measure of inconvenience of having to come back, but everybody would have to come back.
We may not have finished today either. I don't know, Judge. We may have wind up being here at 4:45 and witnesses and who knows, right? So,
I've considered that as well.
Yeah.
I've considered that as well. So with regards to the temporary, this is my concern. It doesn't address the specifics of cyber stalking as is alleged, in which this court has only heard really the one side and not even all of it. But it hasn't addressed to this court's satisfaction, meaning the general language contained in the temporary injunction that's currently in place. It's the buffer zone contact language, but not specifically addressing to this court's satisfaction the posting of YouTube videos and or other social media posts and or other publications or documents, videos, photos, and the like that have been the cause of what is alleged and purports to be, from Ms. Preston's perspective, causing substantial emotional distress.
so you could add that to paragraph 1 because it mentions cyber stalking in paragraph 1.
I want to just be clear what that means.
Okay.
The language that I would propose, hang on, because I've done this before, that the respondent and or anyone under his control, employed by him and or in any way under his direction, including but not limited to any and all administrators of any form of social media, has the responsibility to assure that he does not, nor do they, in any form whatsoever, utilizing any media platform or conduit of information of the name, image, and or likeness, and or any information, data, photography, videos related to or pertaining to the petitioner and or her minor child. It's really it's a stretch on the definition of cyber stalking.
Right. That's what I
but
was going to say. You're in court. It's almost like adopting the statute.
But I don't want there to be misunderstanding
Right.
about what our statute says
Yes.
and the specific circumstances of this case.
Yes. Understood.
So I'm trying to narrowly tailor it and not infringe on his other rights to communication and or speech, but as it relates to this person, this individual.
Yeah, how much of his First Amendment rights are we going to infringe upon? That's the question. And it's more than that as well. I've got the order here, and we'll breeze through the order
So I guess my question then is,
at the end.
if there's consensus on those restrictions, what will be left for us to discuss possibly will be the rescheduling in terms of timing. If there's disagreement about those conditions, it will impact whether or not there's continuance at all, and or whether or not this court needs to hear from you as to what alternative might need to be in place.
Okay.
But I want a clear understanding. And give me just a second to address Ms. Preston.
Sure.
Without counsel, Ms. Preston, I'm not ignoring.
You're not ignoring her. You haven't been paying attention either. She's been walking around the table, banging things around, sorting papers, spending the majority of the time texting.
Needs here. I'm trying to balance what's going on here. So there's plenty of case decisions by appellate courts that allow respondents and you to have counsel of your choice. So that's like two layers: right to counsel of your choice.
If you can afford it.
Representation, which includes a lawyer being represented with enough time and adequate opportunity to prepare, Mr. Shockett represents that he could do so. We haven't got to how much time he's going to need to do so. But the circumstance that's changed, and quite frankly, does significantly change. And if we have to come back, is that you'll have the peace of mind and the protection of the temporary injunctive relief that, quite frankly, would be what Mr. Shockett says when he said you'd be winning. In effect, it would track the language of what a final judgment would look like. But ultimately, we'd still have to come back to determine if, in fact, there's a final judgment, and if so, what its terms are. It would be very similar to this in all likelihood. The real question is for the final then would be for how long? Forever, for a year, for 3 years, whatever.
I understand all this.
Yeah.
But what I know, I'm well aware of what they're doing. He is trying to hold us in contempt of court in Ohio
Correct.
by using false
I know you said
lies.
You said that
He's
to me.
making them
Irrelevant.
up.
Shut up.
He's
Shut
using
up.
them in that court,
Shut up.
and we do not get to defend ourselves against it.
I know, but
And
you
so-
mentioned that to me on the 29th, and I'm not.
Shut the fuck up!
To show just even one or the two things that he's using in Ohio, I can prove right now today are false.
So here's what's
Flat out.
relevant in this courtroom. When we go to hearing, if there's truth to what you just said, which is that he's trying to do these things in Ohio.
He wants me in jail
It
so that I
may-
can't be here.
Shut the fuck up, Donnie.
Okay, so the threat of falsely incarcerating you, I'm going to put that in a broad light, most favorable to you of what you're saying,
Right.
may have relevance and materiality when it comes to this court deciding, has the behavior of Mr. Hales amounted to cyberstalking? But what you have to battle in Ohio about is whether the behavior you're describing amounts to a defense or not of violating the Ohio
Right.
injunction, unless it's brought before this court to adjudicate on the merits whether it's a violation.
She has no idea what you're saying, Judge. You're talking lawyer talk to a tortoise rescuer
If
person.
he's in Ohio doing that, it's got to go to that magistrate or that judge.
I understand.
No, you
He's
don't.
just using the time of this thing to make that case, to try and make that happen. And that's what he's doing. And I do have the times, both times that Mr. Feather called me, of when he called me and offered me all the offers on this case. If
So
he so wanted it over and done with,
he wanted it over and done with at about 4:45 on
exactly.
November 29th. There's no doubt
All he
about
has to
that.
do
I
is
just didn't
agree to
see how we
stop.
could accomplish that and provide due process for all the litigants,
Right,
you and Mr. Hales.
right.
It would have short-circuited that and been an abomination
I
of due
understand.
process from this court's perspective. And I wasn't gonna, not in any case, certainly not in this one, conduct court in such a manner. I am considering granting this continuance based on the fact that there's now a change in circumstance, which is the temporary injunction in place. And what I'm suggesting is additional language. Mr. Shockey, you wish to be heard on the specific.
Oh my God.
Yes, I
Or
don't
any
object
other
to,
matter.
I don't object to what you read gets put into the permanent as far, and we understand they're not to boast something about each other. That the Ohio, this is reciprocal. When you read
So-
Ohio and Florida, but I'm not going to put it in our order, right? I
It
understand.
is and it isn't, okay?
Huh?
My understanding the other day is that, and again, I think it was Ms. Preston that brought it up. I'm not disagreeing with it, but I think she brought it up, Mr. Feather. I don't know if he was in the loop on it or not, but what was said is, Mr. Hales would know, and don't talk to me about it, but you can talk to your lawyer about it, is that in Ohio, there was a discussion about the possibility of doing a mutual injunction. Mr. Hales objected to it. I brought up, when that was mentioned here in court the other day, I said, well, everybody should be aware. I presume the lawyer, Mr. Feather, was aware. There are no mutual injunctions in Florida. However, it could be, and this may be such a case, where the same two individuals can independently have an injunction against the other person, but the court has to look at this case and then look at that case independent. And so it's legally possible and permissible that both people can establish competent substantial evidence to establish that which they need in terms of the relief from the injunction.
Yeah, it talks about, I got the Ohio order, just interesting, but it's not going to be in ours, but this order includes any internet and or electronic communications. They shall not cause or encourage any person to do any act prohibited by this order. So the best thing to calm things down is both parties to stop,
I'm not
Posting-
doing anything, so please stop saying that.
That's-
Oh, shut up.
It's a lie.
Fact.
Shut up.
Decided it.
But I don't object to the language that you had.
I like how they're ignoring her. She's like, and the judge and the other lawyer just are both ghosting her. They're not even listening to her at this point, which I think is kind of funny.
Let me just check with my clerk here. Madam Clerk, I presume you can provide me an extended injunction of the temporary that's already in place. By the way, I may have been remiss, I may have just forgot. The record should reflect that at or about when we called court to order 115 or so, that at that time I wanted the record to reflect. Mr. Hales, you've been served with the temporary injunction, correct? that this court just entered
A
today?
Right here.
sheriff gave me a packet of paper. I handed it off to my representation.
Okay,
So
that is the temporary injunction Mr.
Right.
Shuckett has.
I got it right here.
Okay, so what we're discussing
Now this is interesting. They served him in court. I don't know what the service laws are in Florida, but there, some places you can't serve any court papers on anybody when they're in court. Sort of, they come to court and they become a protected class of people that can't be served. Some places you can serve things like the restraining orders, but you can't serve summons. You can't serve a summons to someone or serve a lawsuit on someone. But you can serve like these. So it depends on what Florida law in this regard is. So I think it's kind of interesting that they served him in court rather than waiting somewhere close by or going to his house. So yeah, people are saying that's illegal to serve in court in Florida. Is that like illegal to serve anything? Like any legal documents whatsoever, or is it a certain type of legal document that can and a certain type that can't? I just don't know, but people in chat are saying you can't do that in Florida.
now, Mr. Hales, is the court is inclined to grant your current counsel's request for continuance on the condition that there's now a temporary injunction. The clerk is going to provide me with it's a standard extended temporary injunction to the date that we're going to talk about when we're going to come back for it. But I'm going to add the language that
1 hour and 6 minutes into this hearing, the judge agrees to give an extension. Let me take you to real life. Let me take you to a real courtroom. This at most is 5 minutes. At most. Best case, you walk in and you say, I'm the newly appointed counsel. I'm going to be taking lead from here on out. I've just got this 24 hours ago, 25 hours ago, however long ago it was. I need a little bit of time to catch up to speed. Your Honor, you set the date as whenever you want. I'll be ready to go whenever it is, just not today. Please grant me the extension. Any complaints, any arguments from the other side? Okay, thank you. We're going to grant it. Done. That's best case. 20 seconds, 30 seconds. Worst case, 5 minutes. This is 1 hour and 6 minutes, which in about 1 hour and 4 minutes of it has been the judge whining, bitching about you didn't agree to this, or I agreed to this, or you didn't show you had to go to this. I don't know why you had to go to Ohio to do a notarization. I don't know. That's all. This is the reason we're delayed. The court is delayed because of court.
you or anyone under your control and or employed by you and or in any way under your direction, including but not limited to any and all administrators of any form of social media, has the responsibility to assure that you do not and they do not publish in any form whatsoever, utilizing any media platform or conduit of information of the name, image, and or likeness and or any information, data, photography, videos.
Yeah, that the full faith and credit to give to other, that's a federal thing. That's just something that
Long
you
way of
do.
cyber stalking from this court's
But
perspective.
he doesn't.
And it will be similar in nature to the peace of mind you're entitled to from the Ohio court, as I understand it in my review of that judgment. It'll
Does
be
that
temporary. It'll extend through the date we come back. And at that point, when the court begins the proceedings, I'm going to go to Ms. Preston and say, do you wish to present your case for it to be longer than, which is to get a final judgment? If she wishes to go forward, we'll go forward and we'll hear the case.
Okay,
Does
just,
that
he has a
cover
quick
John
question. I
Cook?
just confer with him for a second.
Sure,
Okay.
sure.
Does that cover John Cook? It should. I wrote him on the first paper.
I'm sorry.
John Cook, my ex-husband who lives on my property, he was listed on the first order.
So Mr. Cook, it does not have the protection of an extended injunction and would need to.
Septic Boy isn't covered by
He
the
lives on my
order.
property. We live in the same
So
building.
doesn't matter.
I
So
understand that, but I don't have a pleading.
I think it's going to be fine.
It should have been
as a
on the
result,
very
no
first one.
jurisdiction over Mr. Cook.
It wasn't, it should have been covered like he put Miss Riz
it wasn't.
on his, I put John and the baby on mine. It should have been covered for all of us
It wasn't.
on the initial one.
It
It
was.
asks anyone else to be covered under this, and I put John Cook and
John Cook has to put John Cook.
Well, this temporary is going to protect the child, but not Mr. Cook, who is an adult.
Yep. John
All right.
Cook has to say
And
protect
one more
John Cook.
clarification.
It's not filed on his behalf, ma'am. It was filed by you, but not on his behalf.
right, I'll have him file one immediately.
Your Honor, one last
I'll
point, it's
have
very
to.
minor, and I appreciate this. They live right across the street from each other, so this
No,
500
we
feet,
don't.
he has to cross. Ma'am, I didn't interrupt you.
I'm
Please don't
sorry.
interrupt me. He's got to at some point drive on the road which is opposite her house to get to his house. And I think that's less than 500 feet. So can we carve out something, when entering his home, he's allowed to, come closer than 500 feet, like maybe put it 100 feet or something like that.
Your Honor, there's two different ends of our road. One road goes out by his house. One
Shut
road
up.
Goes out by my house. So there's two different exits. We can agree. I will
Hang
go
on,
this
hang
way.
on,
You
hang
can
on,
go
hang
that
on,
way.
hang on. Ms. Preston, if you can raise your right hand.
I'm sorry.
Solemnly swear or affirm the testimony after giving this cause will be the truth, whole truth, and nothing but the truth.
Yes.
Are you in fact
Oh,
saying
yeah.
to the court that Mr. Hales can go to his house and from his house without passing your house?
Yes.
Okay, hang on. Let me talk to Mr. Hales. Mr. Hales, are you disputing that? Do you have to go by her house to get to your house or leave your house?
I do not have to. There is another way to go out on the main highway of Route 19. I own 75 acres. My main ranch is 70 acres. I also own the old Arc building, the schoolhouse. So home is the 70-acre ranch. They intentionally stalked a Otter Creek bought property across the street from us. I have to go through North Otter Creek to get to the schoolhouse where I'm running my business with my employee. I could go all the way around out on Route 19, which is high accident area there in Otter Creek. I'd rather not put myself in danger, rather not put my loved one in danger or my employees in danger. I would like to be able to drive down my road to get back and forth to where I need to be.
What would be the difference in mileage if you had to go out on the main road?
It's probably, I'm going to guess maybe a mile going around in the circle on the main highway versus non-main highway.
I don't think there's a need. There's not good cause or justifiable reason to allow even the ingress and egress. It just doesn't make sense. It's creating and it's perpetuating a problem.
I
Something's
disagree.
going on. There's just no sense in running that risk. You're saying the risk or the downside of this court not carving out that exception is you got to drive a little farther, which I presume to get out of your neighborhood, you're going to drive on that road at some point, and I hope you're a safe driver and pay attention. And
Well,
so
see,
it's a
here's the
little bit of an
problem.
inconvenience,
It's 1 mile. How many times a day? This is an indefinite order because they haven't said when they're coming back to court yet. So this additional mileage builds up every day. It's an inconvenience. There is no reason not to just allow them to use the main road. Give them some sort of a you wouldn't call it an easement, but basically, as he says, carve out a little section that when he's traveling to and from his home, he's allowed to use this certain stretch of road that runs between their two places. That's all you got to do. Any violation of that is a violation of that. It's just being petty.
Pertaining to these cases and multiple cases. I'm not insensitive to it, but it's like justice and the path to get to justice is inconvenient.
It's the same for me, Your Honor.
Shut
I have
up.
to be inconvenienced to
Understand.
go all the way around to go to Chiefland. I have to go out all the way, go to the stoplight. When I could just shoot out in front of him.
I'm entering an order about
Yeah.
Mr. Hales. I
I'm-
want to make sure that he has a way to get to it from his premises.
And I
It's
won't
a
drive
little
by
more
him either.
inconvenient.
1.66.
I won't drive by him either.
Where's the road?
This is the road. Pave it over here on the main highway to get over to the school.
Yeah.
I don't know
Or I
if I
go
can
here,
print right there.
and I don't get
I could take a break and do it. Does this print over there?
So as of right now, I can't send on my property.
Where's the entrance here? You go this way.
This is
Where's your entrance?
my entrance.
So it sounds like his lawyer's trying to get a grasp of what the layout of the property is.
You can enter here. And you can put a camera here. Motion sensor camera 24/7. That's what I want. That's what I need to do that. We're good, Judge. We just realized he can still do it within, it's more than 500 feet away to get into his property. So I withdraw that request.
Okay.
The properties are not, but the way his entrance is over 500 feet, even in the shortcut, even using the shortcut. So he'll be okay.
So let me,
Okay, so he can use the road in front of his house because it's less than 500 feet.
Sends an alert. Is there any movement? You know what I mean? It has a date and time stamp.
take a brief recess. I can go to my computer and
Have someone put it there.
print out an addendum, so it'll be the extended temporary injunction and under the appropriate section. Which one of the- where there's a other- Okay, I'll just
500 feet from her house.
type up that language that I just read in as the addendum.
Not forest. Probably just put where you can see it. Clearly.
You okay?
Hard.
We good?
We're good, we're good.
All right, so let's just stand at ease.
Thank
Give
you.
me 5 minutes.
Okay.
Take it easy.
Is that all right if I run out and change my daughter's diaper with my ex-husband, please?
Yeah, we're taking a break here.
Okay.
If you need a little more 5, just let my bailiff know.
Ugh. It's despicable woman. All right, so we there's a couple of minutes left on part 2. We'll run that up here real quick, but before we do that, let's hit these things here. What about the restraining order? Nay, Faxon says, what about the restraining order that Jeremy has already? See, that's the thing is it's valid, and under federal law, it should be recognized in Florida. But I'm getting the feeling that the judge doesn't think so, which is really, really weird. I don't understand why the judge even has an issue with that. John H. 2004 has been a member for 3 months. It's fun watching your reactions to this, and soon we'll be watching Danny On's reactions. Thanks for covering. And we're going into this because this is a very serious thing where you have a judge that's gone so rogue that, I mean, it is literally affecting the application of justice and fairness in a court, and it just seems to be so ingrained and so entrenched that I'm not just doing this for reactions. I'm doing because I'm fascinated that this is happening in a United States court. This is not something that happens in United States courts. And this judge he's throwing the Constitution out the door. He's throwing basic tenets of law to the wind. And I don't understand. Vince Clortho, YouTube is the official keeper of free speech. Yeah, they're just the epitome of free speech keepers, aren't they? Jeez. Stingy with the $2. Who rants more / worse, Judge Schrader or him? Well, clearly this guy on both counts. Much worse and much more than Judge Schrader does. Ugh. Thanks, Stinge. And Vince Clortho gifted 1 Legal Vices membership. If you got Vince Clortho's gifted Legal Vices membership, make sure you give Vince Clortho, the Keymaster, your super special thanks. Laurie Hinder says, why you have Biden advertising on this before I see you bugs me. I don't have Biden advertising on here before me. If that happens, that's YouTube. YouTube's doing it, not me. Trust me, that would not be me. That would most dev not be me. All right, let's watch the last couple of minutes here. Then we will shut her down. Share the screen. Boom. All right. Let's see. This is actually a different format than the one. Let's see if got. Oh yeah. See, it makes me a little bit bigger, but why not? Who cares? Oh, maybe if we embiggen it. Oh, there we go. That's close enough.
Back on record.
Yeah.
This is a continuation of Hales and Preston. This case is 23 DR 416. All right, so we've prepared the extended injunction for protection against stalking. It includes reference to an addendum, which the court reduced to writing. That'll become part of the directive and the order of this court, the injunction and the injunctive relief.
All right, I know we've only got 2 minutes, but I want to make something real clear right now. John Dalton says, I'm a subscriber. I'm just in a bad situation right now. I don't know if that's talking about super chats or whatnot. Just in case it is, super chats are not required at all to engage with me. They're not expected. They're not required. Absolutely not. It's if anybody does, I gratefully and graciously accept super chats, gifted memberships, things like that. But I do not require it or expect it from anybody. You're all free to hang out. Just you being here is enough for me. Just you participating in chat, you being entertained. You're not here for me by any stretch of the imagination. I am here for you. And if I bring together a group of people, if you guys have fun while I'm doing this, 90% of the time, the chat is talking about something completely different than what I'm doing. I'm here for you. I'm here to facilitate just kind of this little get together we do. We talk law stuff. We talk pop culture stuff. Occasionally they meet somewhere in the middle of this, but nobody should ever feel pressured or sad or ashamed or guilty for not super chat. That is not a thing. That is absolutely not a thing. The only time I ever grift for super chats is on the what I call Fuck It Friday, which we're going to be doing next Friday, the 15th. It's just a pure griftathon. It's all in fun. Or I grift. You all throw, anybody that can throw money throws money. I mean, we do shots for cash, and we have a great panel of guests on and things like that. But no, it is not accepted or required. Please never ever feel pressured in any way to give super chats. So yeah, I don't know if that's what you were talking about. If you were, I just want everybody to know that that's not a thing. And as long as we're positive, we got 780 people here and 683 likes. That is super amazing. That is super awesome. Keep those likes coming. Hit that subscribe button because we are on the quest for 69,000 subscribers. And currently we have 68,994 subscriptions. So we are 6 subscribers away from 69,000 subscribers. So the next Friday, the Effin' Friday, will be not only a St. Patrick's Day celebration, it will be a 69 celebration. We'll all get together and celebrate 69. It'll be a super festive giant 69 party. How does that sound, people? So if we only need to get 4 more subscribers for that to happen. So if you haven't subscribed, you might be the lucky one. You might be the lucky one that pushes us over into a great big giant 69 party on the 15th of April. So yeah, go on over there, hit that. Oh, we got it with boom. That is good. Boom, we got it. That is super awesome. Yay. We are now at 69,001. So I think that's pretty damn awesome. Thank you, everybody. That's way cool. All right. You guys rock. Seriously, I've only been doing this just a couple of, not even 2 years. It'll be 2 years in May. And we're at 69,000 subscribers. We're working our way to that 100,000. So again, thank you so much for that. You guys rock. That is way cool of you all. Thank you so much for the support.
Set forth in
Love you guys.
the order will remain in place through January 4 at 9:00 a.m. when we reconvene in this courthouse and in this courtroom.
I'm sorry, I missed the date.
Or at 9:00 a.m. when we reconvene. Or at the place, the order will remain in place through January 4 at 9:00 a.m. when we reconvene in this courthouse and in this courtroom for the resolution of the rest of the matters in terms of presentation of evidence of that which began on November 29. The respondent's motion to continue, filed 12/5/23, is granted. The continuance will be to the January 4th date at 9:00 a.m. So, Mr. Hales, I just want you, I'm not expecting that you'll violate the terms of this, but you're entitled to be aware of the fact that a violation of the terms of the injunction, including the language that's contained in the addendum that I've already read to you, in Florida.
Oh, sorry. Yeah,
one of
right.
2 ways. Initially, it'll go to the office of the state attorney. They can prosecute it as a first-degree misdemeanor, which is punishable by up to a year in jail. If they do not pursue it, then it gets remanded back to this court to pursue, if at all, as a matter of contempt. Potentially, you'd be facing up to 6 months incarceration. You understand a violation could result in either of those. You understand that?
Yes.
Okay. Do you have any questions for the court?
No, sir.
Okay. And then the second part of it, again, I expect you'll be here, but you understand it's your obligation to be back in court on January 4 here in Levy County.
Yes.
All right. I'll see you then. Counsel, anything further on your plans we have?
Thank you, Judge.
Ms. Preston, anything further from you or any additional questions or anything?
No.
Okay. All right. We'll stand adjourned. I'll see you all, if not before, maybe Mr. Shockett in the new year.
All right. Happy New Year.
Good luck to you all. I'll see you then.
I think I'm going to see you tomorrow too.
Am I okay?
You going to the circuit?
I guess they're done. Wait a minute. Yeah. Okay, so everybody's leaving. All right. Well, see, now I have a question. Someone mentioned this here in chat. Where did it go? Oh, bomb threat gone. The guy behind LIEnette is gone now. The bomb threat comes in. They had a bomb threat? I didn't know that. Huh. Really? A bomb threat. You don't say. That's kind of wild. Sorry. Nope. John, I thought I just saw the one thing and I thought it was about you're clearly begging for money. This is exactly the same message that you or someone else sent a few weeks ago. That doesn't happen here. Sorry. No, nobody do this. Right. Bye. Gone. Yeah, that doesn't happen here. What I said about all the super chats and not required, that is true. But if it's, I'm on the side of the highway and I got, call AAA, call the local sheriff's office, call the local cops. They'll help you out. They'll give you a push. They'll take you to gas. They'll do something. Sorry guys. I just saw the thing and I thought it was someone who was apologetic for not sending super chats. It was just a scammer. So later, Grizzly dude. Okay. Island with a $2 super chat says if she purposely bought near him, how did they meet? Apparently she was a fan of his. From what I've been able to put together, she was a fan, and I'm sure you'll all correct me if I'm wrong. She was a fan. He moved there, she moved there. She wanted to get some money from him. She wanted to cash in on his fame. And he rejected it, kind of like we did to Scammer John here. And then she went nuts. That's the story in a nutshell, as I understand it. All right. Well, he got the protective order. Hey, Joe, member for 13 months. Congrats on reaching 69K. Thank you. Thank you. Thank every one of you. Thank all 69,010 of you now. That's way cool. Just get 30,000 of your best friends here and we'll get our little silver plaque because that's what I'm going for. But no, thank you so much for your support. You guys are so awesome. We were at 68,000 2 days ago. So that's how many of you guys have come and started. We've got 1,000 subscribers in 2 days. That's very, very humbling. I don't understand it. I don't get it, but man, you guys are great. And as I've said before, when dealing with a new topic like this, especially someone that has such a huge following like the Hales do, you're being very, very nice to noobs, myself included, as we try to wrap our heads around this weirdness of how a judge can do this in the U.S. and why the judge would do it. And I mean, these are some weird facts, but thank you so much for having a little patience, a little kindness. Your comments on the videos, there's so many I can't acknowledge them all, let alone. But you're so helpful and you're so grateful and very, very educational and instructional. You provide lots of information. I appreciate it because then I can talk about the information you tell me and I can pretend I knew it and it makes me look smart. So I appreciate equality with the 690 California. Congratulations. Sorry, can't afford 69. Well, 69 cents is cool too. Thank you so much. Thank you so much. And all right, here's what's coming up. Tomorrow, Friday. On Fridays, we do Friday evening show instead of a Friday morning show. So Friday evening at I guess it'll be right around 8 or 9 p.m. on Friday evening. There's developments in the Maya Kowalski case. The Take Care of Maya. We talked a lot about that here. We did a lot of the post-trial stuff. We had Greg Anderson, Maya Kowalski's lawyer, on here. Megan Fox was a big part of that. There's been developments in that case. And we're going to cover something very, very interesting about that tomorrow on Friday. Monday, starting on Monday again, we're going to go back. I'm debating whether to go straight. Okay, there's 720 of you here right now. We're going to do a flash poll because I can't decide. Part of me wants to, when we come back on Monday, part of me wants to do the her deposition, and the other part of me wants to go to the third hearing. What should we do, chat? Put 1 if you want me to do the deposition on Monday. Put a 2 if you want me to go to hearing number 3 on Monday. So 1 for the deposition, 2 for hearing number 3. I'm waiting to see what happens. 2112, hey Joe is always the answer. But you know, in this case, we do need ones or just lots of ones. We're starting out almost all ones for the okay, there's about 3 2s scattered in. Looks like it's going to be deposition. Next time we talk about this on Monday will be deposition day. So, all right. Whew. Okay. So tomorrow will be the Maya Kowalski development. Monday will be the tortoise queen's deposition. Tuesday will be day 3 hearing. Probably do day 4 on Wednesday. I mean, hearing number 4 on Wednesday. And Thursdays, what we do on Thursdays, if we're not covering trials or things, we do a retro trial. So you can see how cases, I can talk. We can hear how, you can see and watch how cases were heard and argued in the past. We've been doing for over the past year now, the O.J. Simpson trial, some highlights from that. Right now, we're in the middle of the O.J. Simpson trial closing arguments. We should finish that in 2 weeks. And then after that, we're going to start another old case about an older gentleman who took out his mother and his siblings in a manner that the prosecution argues was ritualistic and tied to witchcraft. It was a pretty cool case, and we'll watch that when we finish with OJ. So Thursdays we do the trials, and also normally on Mondays we do Maritime Monday, because a lot of what I do is maritime law, and we talk about shipwrecks and cannibalisms and submarine things, and you know the Titan submersible that got crushed a while back. We talk about shipping and maritime and old sea cases and ghost ships and really cool stuff on Mondays normally. So we'll do OJ next Thursday and next Friday the 15th. Friday the 15th, starting at probably 7 or 8 p.m. Eastern time. That will be our March Fuck It Friday, where we say fuck it. And that's the Griftathon. That's where I get on my knees and beg for money and demand that you supply me with alcohol shots. It's all fun and games because it's built around having an entire panel of amazing guests. We get everything from stay-at-home moms to OnlyFans models and lawyers and influencers and everybody in between. It's a great time. Everybody's there, and some of your favorite people will be there. I guarantee you. So that's what's going to happen up until next Friday. So thank you, everybody. Oh wait, it's Thursday, isn't it? All right, yeah. So that takes care of a week and a day. Sorry, I just had like my brain freeze there for a minute. People, let's see where we're going to send you. Who is doing what right now? I think we need to check the tubes. What's going on the tubes? The studio. Studio. La 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 la. Why isn't it going to studio? Here we go, studio. YouTube studio. Go to content. Hang tight, everybody. I'm looking for a place to send you. Vince Clortho says, I'm still confused. Yeah. Me too. I'm still really confused. Right, here's today's stream. Go to customization and go to redirect. Ooh, there's a lot of people covering the Crumbly trial. Fannie Willis, the Oxford school shooter's dad. That's the Crumbly trial. Something I've never heard of before trial. All right, let's do a randomization. Let's go check out. I'm so confused. Let's go to Good Logic. We haven't had a Good Logic Joe raid in a while. We're gonna go to Joe of Good Logic. He's talking Fannie Willis right now. So everybody, let's go on over and see. He's talking about the Board of Ethics examining Fannie in public hearing. Joe, that is a video title if there ever was one. Examining Fanny in public hearing. So let's go over to do Good Logic Joe and tell him Legal Vices sent you and see what he's up to. Give him all your love. We'll see you tomorrow for developments in the Maya Kowalski trial. Super, super interesting thing there. And we got a little insider tidbits from there. So see y'all later. Mods, thank you so much for being mods. Thank you so much for your support, chat. Thank you just even for being here and talking amongst each other. And thank you so much for the likes and the subscriptions. We'll see you tomorrow. Lorax saying peace. Oot.